Good afternoon, everyone. Today we will begin with tort law, and thereafter we'll proceed on to discussing about real, personal, and intellectual property law. Let's start with tort law. So to understand tort law, it's very important to first know what is tort and why should we learn tort law. You see, a tort is an action or an omission that gives rise to an injury or a harm to another person, and it amounts to a civil wrong for which the courts they impose liability. So in the context of torts, injury describes the kind of invasion of a legal right, whereas the harm describes a loss or a detriment in fact that an individual suffers. In this regard, it's very important for us to distinguish torts from crimes. You see, crimes are the wrongs against the state or the society at large. And the main purpose of criminal liability is to enforce public justice. And in contrast, tort law addresses the private wrongs, and it has a central purpose of compensating the victim. The central purpose is of compensating the victim rather than punishing the wrongdoer, unlike that happens in crime. So some acts, however, may provide a basis for both tort as well as criminal liability. For example, gross negligence that endangers the life of others may simultaneously be a tort as well as a crime. And likewise, some actions are punishable under both criminal law and tort law, such as battery. In that case, ideally, the tort law would provide a monetary remedy to the plaintiff, while criminal law would provide rehabilitation for the defendant, while also providing a benefit to the society by reforming the defendant who committed the assault. In this regard, we also need to distinguish tort law from contract law. You see, although a party may have a strong breach of contract case under contract law, a breach of contract is not typically a tortious act. It does not fall under tort law, a breach of contract. Note that the tort law is the area of the law that covers most civil suits. Generally, every claim that arises in the civil court, with the exception of contractual disputes or breach of contract, they all fall under the tort law. Therefore, we can say that tort law requires those who are found to be at fault for harming others to compensate the victims. And typical harms here includes the loss of, let's say, past or future income, payment of the medical expense, payment for pain and suffering. And it may also include additional punitive damages that are meant to punish the defendant in excess of the full compensation that the plaintiff receives. So to summarize, a tort is a wrongful act resulting in injury or damages for which the civil law it provides that the injured party can seek recovery from the person who has caused the injury. So the person or the party who suffers the harm from this wrongful conduct of another is known as the plaintiff or the claimant, and the person or the party who has caused the injury is known as the defendant or the tortfeasor. The lawsuit is also called tort action. So remember that there are three elements in a tort action, which are often referred to as the three-legged stool. All three must be present to have a valid claim. So these are: one, there should be a duty; two, a breach of that duty; and three, damages resulting from the breach of that duty. And the plaintiff here must show that the defendant was under a legal duty to act in a particular fashion, and that the defendant did not act according to that duty or breached that duty, and that the plaintiff has suffered injuries or losses, also known as damages, as a result of this breach. And whether the defendant violated a duty owed to the plaintiff is determined by the common law or by statutory law. The common law, you see, is a general body of laws that has developed over many years through court decisions or opinions. And in the United States, this common law sometimes even goes back to the common law of England. And statutory law is the body of the law established by the written laws passed by the legislature. Now we will look at the classification of tort. You see, torts fall into three general categories, and these are intentional torts. For example, intentionally hitting a person, or negligent torts. For example, causing an accident by failing to obey traffic rules, and strict liability torts. For example, liability for making and selling defective products. So intentional torts are wrongs that the defendant knew or should have known that it would result through his or her actions or omissions. It can be actions or omissions. It refers to the harm done to the people intentionally by the willful misconduct of another, such as assault, fraud, and theft. For example, throwing a punch in a fight is intentionally engaging in a destructive behavior. In such a case, a plaintiff can file an intentional tort suit. So examples of intentional torts, they include battery, conversion, false imprisonment, defamation, as well as assault. And there is also something called negligent torts, and these occur when the defendant's actions were unreasonably unsafe. And this encompasses the harm done to the people generally through the failure of another person to exercise a certain level of care, which is usually defined as a reasonable standard of care. Reasonable standard of care. And accidents are a standard example of negligent torts. For example, a janitor has a duty to put up a wet floor sign after mopping the floor. And if the janitor fails to put up the sign and someone, let's say, slips and injures himself or herself, a negligent tort case may be filed in this regard. So examples of negligent torts, they include, let's say, car accidents, bicycle accidents, medical malpractice, as well as legal malpractice. And unlike the intentional and the negligent torts, this third category, that is strict liability or absolute liability torts, they do not depend on the degree of care that the defendant has used. Rather, in strict liability cases, the courts, they focus on whether a particular result or harm has manifested. Therefore, strict liability torts are not concerned with the culpability of the person doing the harm. That is the difference between strict liability and other kinds of intentional torts. In strict liability torts, these are not concerned with the culpability of the person doing the harm. Instead, you see, strict liability focuses only on the act itself, only on the act. So if someone or some entity commits a certain act, for example, let's say producing a defective good, then that person or that company is responsible for the damages from that act, regardless of the level of care exercised or their intention. So for example, if a company releases a defective product for consumer consumption and the consumer is injured as a result of that defect, strict liability is imposed and the company will be held liable. So examples of strict liability torts also include animal attacks, which is also known as popularly as dog bite lawsuits, or defective products or product liability, and abnormally dangerous activities. Now we will be looking at intentional torts against a person. You see, civil wrongs of intentional interference with one's person or reputation or property, these are known as intentional torts. So we'll be taking a look at them one by one. First is assault. You see, assault can simply be defined as a reasonable apprehension of immediate battery. So when we look at the elements of assault, it says it's an act by the defendant that causes reasonable apprehension in the plaintiff of immediate harmful or offensive contact to the plaintiff's person and the intent on part of the defendant to bring about such an apprehension, and the third one is causation, right? So always note that there are also two aspects. There are two aspects of causation which are known as cause in fact and or actual cause, and proximate or legal cause. So cause in fact or actual cause, it simply means that the injury would not have occurred except for the fact of the defendant's intentional action or negligence. So cause in fact or actual cause is very straightforward. So when a bus strikes a car, when a bus hits a car, the bus driver's actions are the actual cause of the accident. About proximate cause or legal cause, you see, proximate cause or legal cause, on the other hand, is tricky in the sense that the law should recognize the cause as the primary cause of the injury. And it may not be the first event that set in motion a sequence of events that led to the injury, and it may not be the very last event also before the injury occurs. So instead, it is an action that produced foreseeable consequences without intervention from anyone or anything else. In other words, the plaintiff here will have to show that the injuries were the natural and direct consequence of the proximate cause, without which the injuries would not have occurred. Remember that some states, they follow the but-for rule to determine if an event is the proximate cause. And this rule considers whether the injury would not have happened but for the defendant's negligent action or omission. And when there is a finding that the injury would not have happened but for the defendant's action, it establishes the element of the proximate cause. For example, when a drunk driver is, let's say, weaving in and out of traffic and the driver hits the pedestrian, causing massive hemorrhaging and brain damage, the accident would not have happened but for the drunk driver's intoxication. And it is also foreseeable that if a driver is drunk and weaving through the traffic, the driver may cause injuries to a pedestrian. That's obvious. However, a defendant cannot be liable for totally unforeseeable injuries. So for instance, if the same drunk driver, let's say, hits a warehouse full of explosives, and there's an explosion that causes the drivers to rubberneck and hit the pedestrian, the drunk driving is probably not the proximate cause of the pedestrian's injuries. Another thing we need to take a look at is the substantial factor test. You see, other states, they also use the substantial factor test in connection with proximate cause. So under this rule, the court will consider whether the defendant's actions or omissions were a substantial factor in causing the injury. In jurisdictions that follow the substantial factor test, a substantial factor is one that contributes materially to the occurrence of an injury. An action contributes materially when its causative effects are in operation until the moment of the injury. And an action or an omission that only trivially affects the occurrence of an injury is obviously not a substantial factor and will not be considered a proximate cause. For example, let's say if a distracted or a drunk driver crashes into a truck carrying explosives, and as a result, the explosives explode and kill the truck driver, the distracted driving is a substantial factor in the accident. The distracted driver's actions are in operation until the truck explodes. However, if a distracted driver, let's say, crashes into a stop sign, and in order to avoid the site of the accident, the tractor trailer driver turning left swings particularly wide such that the portion of the truck carrying the explosives hits a parked car and explodes, killing a passing pedestrian. In such a case, the distracted driver's actions affected the pedestrian's death only incidentally, whereas the truck driver's swinging wide turn is a substantial factor in his or her death. We also need to take a look at the difference between apprehension versus fear or intimidation when we are talking about assault. You see, apprehension is a knowledge or awareness or expectation of a harmful or offensive contact. And one may not have fear, but one may still have apprehension. And apprehension here means awareness. This apprehension may still exist, and the elements of assault is satisfied. So if there is no apprehension, let's say, that is if the plaintiff did not see it coming, it is not an assault. For example, let's say defendant was about to slap the plaintiff from behind, but he changed his mind at the last moment. In such a case, was there an assault? Answer is no. There was no apprehension and therefore no assault. But let's say he was about to slap P from the front on his face. In such a case, there is a reasonable apprehension in P, in the plaintiff, and therefore we can say that the defendant has committed an assault. Let's take an example. A points, let's say, an unloaded gun at B, and B says, I am not afraid to die. You see, apprehension exists, but fear here is absent, and this is assault. So long as apprehension exists, it is an assault. Fear is not important. But let's say if B knows that the gun is not loaded, it is not an assault. Or if A's gun is actually loaded, but B thinks that the gun is not loaded and he laughs off the matter, it is not an assault. And let's take another example. A points a loaded gun at B while B is sleeping. Is there an assault? No. Why? Because there is no apprehension as well as no fear. Therefore, there is no assault. Here you must note, when we are talking about assault, first of all, that the knowledge of the defendant's identity is not necessary. It's not necessary for the plaintiff to know who the defendant is. Second, the hostile action alone may constitute an assault. Hostile action is enough to constitute an assault. Mere hostile words, however, is not an assault. For example, I will punch you, I will beat you up. These are hostile words. These are not assault. However, hostile words together with a hostile overt act is an assault. For example, A tells B, I will punch you, and then A rushes towards B with a clenched fist. In this case, B can file a lawsuit against A for assault. Also remember that hostile overt act may be negated by the words used, and the end result may not actually be an assault. For example, let's say A has clenched his fist at B and says, if you were not my best friend, I would have beaten the crap out of you. In such a case, although there has been a hostile overt act, however, this hostile overt act has been negated by the words that A has used. Therefore, the end result is not an assault, because A is telling B that if you were not my best friend, I would have beaten the crap out of you. And also remember that conditional threat may be an assault. For example, A has pointed a gun at B and says, your money or your life. Here, A has given B a condition, give me your money or I will take your life. This is an assault because there is a reasonable apprehension of harm in the mind of B. Also remember that the threat must be immediate. The threat cannot be remote or distant, or the threat of future harmful contact is not considered an assault. And also remember that it is not necessary to prove actual damages in assault. Therefore, to sum up, we can say that assault is an intentional tort when one is placed in reasonable apprehension of an intentional, imminent, unconsented, harmful or offensive touching by another person. Assaults occur when the targeted person's anxiety is the product of the actor's threatening conduct, such as stalking or placing a gun in front of one's face. It does not matter if it is loaded or not. as long as the individual has a reasonable apprehension of some offensive contact or harm, an assault has occurred. Now let's take a look at battery. Let's take a look at the elements. So battery can be said to be an act that brings harmful or offensive, that is unpermitted, contact to the plaintiff's person, and there is an intent on part of the defendant to bring about such a contact, and there should be causation. When we think about battery, a reasonable person standard, which is an objective standard, it will be applied. So anything connected to plaintiff's person, also remember, is also known as plaintiff's person. For example, let's say holding, touching, or carrying. An example, a purse, a cane, or a dress. These are all plaintiff's person. For instance, swatting the rump of a horse on which the plaintiff is riding can also be said to be a battery committed to the plaintiff. Also remember that here the causation may be direct or indirect. That is, the defendant would be setting in motion a force that brings about a harmful or an offensive contact. Also note that the plaintiff need not be aware of or apprehend the harmful or the offensive contact. For example, doctors performing an unauthorized or an unpermitted surgery on an unconscious patient. This one will be considered to be a battery. Or take, for example, A has punched B from behind, and this is a battery even though B was not aware or apprehended that A will be punching him. Remember that battery need not be harmful, and offensive contact is enough. It need not be harmful, just an offensive contact is enough. For example, a boy is stroking the girl's hair without her consent or permission. This is battery. So, and the instance is an unauthorized surgery is also a battery. And in this kind of cases, nominal damages is recoverable, but the surgery is unauthorized, even though the surgery was successful. Why? Because there is an offensive contact element here, even though it is not a harmful contact. And here, the test, remember, is always that of a reasonable objective person and not an extremely sensitive person. For example, tapping the shoulder of a person to draw the attention can be deemed offensive by extremely sensitive person, but it is never a battery. But on the other hand, compare that the boy is stroking the girl's hair without her permission or her consent, this is a battery. Also remember that battery can be time delayed. For example, the defendant has poisoned the sandwich of the plaintiff, and plaintiff has consumed the sandwich after 2 years, and the plaintiff falls severely sick. In such a case, the defendant is liable for battery against the plaintiff. And remember that it is not necessary to prove actual damages in battery. And also, knowledge of the defendant's identity is not necessary to have this element of battery. Thus, battery can be defined as an unpermitted, unprivileged, intentional contact with another's person. And this tort includes contact that is actually harmful, as well as the contact that is just or merely offensive. And unlike with an assault, it is not essential that the plaintiff be conscious of the contact at the time it occurs. Now we will look at defamation. Defamation. So what are the elements of defamation? You see, a defamatory statement, defamation can be said to be a defamatory statement. And what is a defamatory statement? It must be an untrue statement of facts to be actionable, and it must also hold the plaintiff to ridicule, hatred, contempt, or scorn. It's a defamatory statement that identifies the plaintiff. What do you mean by identifies plaintiff? It means the plaintiff must be sufficiently identified to a reasonable reader, a listener, or a viewer. A defamatory statement identifying the plaintiff, and there must be a publication of that defamatory language by the defendant to a third party or the public who understands it. It's very important to know that the third party should be able to understand the import or the essence of that defamatory statement, and there should be a damage to the reputation of the plaintiff. And if it's a public figure or a matter of public concern, then there are two other additional elements that must be considered to establish defamation. One is falsity of defamatory language, and the second one is fault on the defendant's part. Fault on the defendant's part. A few things to note here when we are talking about or trying to establish defamation. What are those? First of all, let's consider defamatory language. You see, adversely affecting one's reputation. This is basically defamatory language. It should adversely affect one's reputation. That means it should cast a shadow on the honesty, integrity, virtue, sanity of the plaintiff. And this statement of fact must be in fact untrue. That is very important. The statement must be untrue. It can be expressed or it can also be by innuendo. For example, the defendant, let's say, publishes an erroneous story that the plaintiff has given birth to twins. And this is defamatory as the plaintiff pleads and establishes that she has been married only for 1 month. Here, note that mere insult is not defamatory. For instance, saying John Smith is a crappy person, this is not defamatory. But on the other hand, if we say that John Smith has caused 3 people to die during surgery last year, this statement is defamatory. It is a false statement of fact. So when we think about defamation, what are the methods of defamation? It can be through a direct remark, it can be through pictures, through written statements, through satire, through drama, etc. What about when we think about defamation, we have to also know whether statements of opinion can constitute a defamatory statement. You see, statement of opinion can constitute defamation and it can be defamatory only if it is based on specific facts and an express allegation of those facts. For example, I do not think plaintiff can be trusted with the key to the cash register. Why? Because we are casting aspersions on the honesty and the integrity of the plaintiff. We are trying to say the plaintiff is a thief. That's why we are saying that I don't think plaintiff can be trusted with the key to the cash register. However, statements such as plaintiff will rip you off, or plaintiff is a sleazebag, or plaintiff is an unscrupulous person, or the plaintiff sucks big time, these are not defamatory statements, as these are merely hyperbolic statements of opinion. So unless such statements are supported by statements of facts, they are not considered to be defamation. What about publication? You see, the defendant must publish or share the statement with any other person other than the plaintiff, be it intentionally or negligent. Publication may be deliberate, it may be negligent, or it may be accidental. For example, employer defendant, he has called the employee plaintiff, let's say, to his office and tells, I think you are a thief and you have been stealing the office funds. And negligently, the defendant has left his intercom on and everyone in the office could hear what the defendant had told the plaintiff. It was a negligent action, it was accidental. However, the defendant will be liable to the plaintiff for defamation. Or in this case, compare, if the defendant had told the plaintiff in his office, I think you are a thief and you have been stealing office funds, and the defendant's office, let's say, was wiretapped, and defendant did not know about it and the police has overheard it, this is not considered to be defamation. Okay, so who may be defamed? We are talking about defamation. Who may be defamed? First of all, remember that living individuals can be defamed. Dead individuals cannot be defamed. Corporation, association, etc. can also be defamed. Okay, let's talk about now publication. As we had discussed a bit before, that there must be a publication of the statement. That is, there must be a communication to the third party who has understood the defamatory statement. And publication may be intentional or negligent. For instance, A publishes defamatory statement against B in Japanese language, and B's friend C sees the statement, and neither B nor C can understand Japanese. There is no action for defamation here, because here the third party, although a communication has been made to the third party cannot understand Japanese, so there is no defamation. Or let's say X and Y, they take Russian language class and Z takes French language class, and during the lunchtime they all meet, and X tells Z in Russian that Y has cheated in her exam, and this is not defamation so long Z does not know Russian, because Z here only knows French, he does not know Russian. And the test is whether it is reasonably foreseeable that the third party will know about or be aware of the defamatory statement. For example, defendant has sent a defamatory statement about the plaintiff to the plaintiff who is a child, and the plaintiff has handed it over to his father to read. Here, the defendant is liable for defamation. Or the defendant has sent a defamatory statement about the plaintiff to the plaintiff who is a blind man, and the plaintiff has handed it over to his friend to read. Here also, the defendant is liable for defamation. What about intent? You see, in the case of defamation, to establish defamation, only the intent to publish is enough, or it can also be a negligence. What about repetition of defamatory statement? In this case, you see, each instance of publication of defamatory statement will give rise to a separate action to recover the damages. For example, in the case of newspaper, magazine, book, these are also called single publication. And who is liable in such a case? The primary publisher will be liable, that is the newspaper publisher. The TV station carrying the defamatory statement is primary publisher and responsible for that message to the same extent as the author or the speaker of the defamatory statement. And here in this case, remember that the internet service provider is not liable for the defamatory statement of a user. What about republisher? Republisher can also be held liable to the same extent as the primary publisher, even if the republisher may not believe in the defamatory message. What about secondary publisher? Here the secondary publisher will also be liable only if they know or should have known of the defamatory content. So examples here are newspaper vendors. Another thing to remember here is the damage caused to plaintiff's reputation. You see, damages are of two types: general damages, special damages. General damages are basically compensation received by the plaintiff for the general injury to plaintiff's reputation, for example, loss of friends, humiliation, or wounded feeling. What about special damages? Here the plaintiff must prove that there has been a pecuniary or an economic or a monetary loss. For example, loss of job, loss of prospective gift or inheritance, or loss of custom. What about damages in libel? You see, libel is a defamatory statement in writing or other permanent form. For example, a newspaper, a radio, a TV, or tape, etc. And in libel, the general damages are presumed and it's always a given. What about damages in slander? Slander is a spoken defamation. Libel is a defamatory statement in writing, and slander is a spoken defamation or a verbal defamation. Here, the injury to reputation is not presumed, and special damages, for example, that is economic harm or loss, it must be proved. However, there is some exception, and these exceptions are that special damages need not be proved. That is, in these cases, the damages are presumed. What are these cases? This is also known as slander per se. Slander per se. So these special cases, for instance, are business or profession. For example, saying a statement that engineer X is a terrorist. This is not a defamatory statement. But saying that accountant X has fudged the numbers, this is a defamatory statement because it is related to the business or profession of X, who is an accountant. Or loathsome disease, making a statement that someone has leprosy, venereal disease. Example, gonorrhea, syphilis. These are all defamatory statements if it is not true. For example, another case is crime involving moral turpitude. Basically, a statement that suggests depraved morality of the plaintiff. For example, saying that X has a mistress, or X has committed tax evasion, or X is a murderer. These are crimes involving moral turpitude. Or a statement that says or that suggests the unchastity of a woman. For example, Susie is a prostitute, or Debbie knows the Jets very well inside and out. She sleeps with them. These are all defamatory statements. However, note that it does not apply to men. For example, saying that Tony is a player with women, he is a playboy. This is not a defamatory statement. What about falsity? You see, the plaintiff must prove that the defamatory statement was false. It's very important. And when we talk about the fault of the defendant, here two things have to be kept in mind. That is, if it is public officials, if the defamatory statement has targeted public officials and public figures, they must prove that the actual malice is involved. They must prove that element of actual malice. And you see why? Because public figure is someone who has achieved pervasive fame or notoriety, or he has voluntarily assumed a central role in public controversy. And what is actual malice? What is this element of actual malice? It is the knowledge that the statement was false or reckless disregard of the truth or falsity, that is, recklessly presenting something as truth when the defendant himself may seriously entertain doubts about the truthfulness of the statement. So if defendant reasonably believes, even if he is wrong, that he is correct, then defendant is not liable for actual malice. About private persons. You see, private persons need not prove actual malice. It's not necessary. Proof of negligence enough. Proof of negligence is enough. That is, the defendant did not make a reasonable effort to verify. This is the standard of proof of negligence. And it should also note that there should be matters of public concern or newsworthy. That means the plaintiff must prove falsity and fault, that is deliberate falsehood or reckless disregard of its truth. And negligence must be proved, an actual injury, that is pecuniary loss, loss of reputation, loss of standing in the community, etc. This must be proved also. And if actual injury cannot be proved, in that case, the plaintiff must prove actual malice. And what about matters of private concern? You see, here only the four elements of defamation, that is defamatory language, of or concerning the plaintiff, publication and damages. These are the four elements. These are all that is necessary for the action. And what about defenses to defamation? You see, there can be several defenses to defamation. First is consent. That is, the plaintiff has consented. It can be expressed or it can be implied. Second is truth, especially in the cases of private concern. Here, the burden will fall on the defendant to prove the truth of the statement that he has made. There can also be absolute privileges, such as a judicial proceeding, a legislative proceeding, or executive proceeding. Note here that in judicial proceeding and executive proceeding, there must be a reasonable relationship between the defamatory statement and the proceeding at hand. In legislative proceeding, however, there is no such requirement. Also, under absolute privilege, it can also there be compelled broadcast or publication as well as communication between spouses. You see, there is cannot be a defamatory statement when there is a communication between the spouses. And there can also be qualified privilege, and these are usually applied in cases of honest mistake. What are these qualified privileges? First is reports of public proceedings. Here, note that the reporting must be accurate, though the statement may be false. And inaccurate reporting cannot be excused. Also, the second case of or instance of qualified privilege is public interest in encouraging the candor. Here, the publication to one acting in public interest, for example, a parole board, fair comment, criticism, these are all qualified privileges. But there must be reasonable and good faith belief that the statement is true. And the statement must also be confined to the relevant material. It cannot be used to interject extraneous information. Another kind of qualified privilege is interest of the publisher of the defamatory statement. Why? To defend own actions, maybe, or own property, own reputation, etc. Or it can also be in the interest of the recipient. For instance, a former employer makes a defamatory statement against the employee to the new employer. Or there can be common interest between the publisher and the recipient. For example, A, B, and C are board members of a company, and A makes a defamatory statement against B's business practices or decisions to C. This is not a defamatory statement as it falls under qualified privilege. So you see, defamation is an intentional tort that provides targeted individuals with remedies against persons who intentionally make malicious statements that injure the target's character, fame, or reputation. And generally, the truth of the statement is a complete defense in a suit for defamation because true statements are not considered, obviously, to be malicious. And also remember that there are two forms of defamation, and these are libel and slander. So libel is a defamatory statement or a defamation which is expressed by print, writing, signs, pictures, and normally also radio and television broadcasting. And slander involves spoken words that have been heard by someone other than the plaintiff or the target. And also remember that some actions are known as slander per se or slander in and of themselves. And slander per se consists of especially egregious offenses, including false accusations that another person has contracted a morally offensive communicable disease, and the defamatory expression impacting directly on one's profession, such as stating that a particular lawyer is a cheat, a particular lawyer is a crook, or that the doctor is a quack. These are defamatory statements and these are slander per se. Now we will look at another type of intentional torts against a person, and this is known as intentional infliction of emotional distress. Intentional infliction of emotional distress. What are the elements here? To establish intentional infliction of emotional distress, it must be an extreme or outrageous conduct intended to cause the plaintiff to suffer severe emotional distress, or a reckless conduct by the defendant that results in severe emotional distress. And there must be a causation, that is proximately it had caused the plaintiff's emotional distress, and there must be damages, that is actual damages, that is severe emotional distress must be the result and proof. And physical injury or pecuniary loss is not relevant. So here, intentional infliction of emotional distress can be said to be an outrageous conduct plus intent or recklessness to cause the plaintiff to suffer the severe emotional distress, plus there must be an actual severe emotional distress. Note that not just severely distressing the plaintiff, but severely distressing the plaintiff by outrageous or extreme conduct. A plaintiff can be severely distressed by any reason or whatever action of the defendant. But to make this an intentional infliction of emotional distress, the defendant must have committed an outrageous or extreme conduct. For example, what are these actions? Dumping a date while out on a lavish dinner is not an intentional infliction of emotional distress, as it is not extreme or outrageous conduct. But dumping a to be bride just before the marriage altar, vows have to be taken. This is an intentional infliction of emotional distress. So, what are these outrageous conduct? When we speak about outrageous conduct, it means that the conduct must exceed all bounds of decency that is tolerated by the civilized society. For example, extreme business conduct. For example, extreme methods used by the collection agency or misuse of authority. For example, school authorities, they are bullying the student, or offensive or insulting language. This can this is only applicable, you see, when there is a special relationship between the plaintiff and the defendant, and the defendant is aware of the plaintiff's sensitivity. That is, mere insults are not outrageous, or a special relationship situation. For example, let's say common carriers and innkeepers, they owe special duty to the patron, or the defendant had knowledge of the sensitivity of the plaintiff. For example, that is the defendant. He knew of the plaintiff's special situation. And who is the plaintiff in this regard? It can be children, it can be a pregnant woman, it can be elderly people. For example, a defendant has called an elderly woman, "You fat old cow." This one, in this case, the defendant may be liable for intentional infliction of emotional distress or intentional mishandling of a relative's corpse. This is also an intentional infliction of emotional distress. So, how can we test the outrageous or extreme conduct? You see, when the bad behavior is repeated, or for instance, when the defendant is a common carrier or the innkeeper, or when the plaintiff is a member of the fragile class, or when the defendant knows of the plaintiff's sensitivity. And here remember that the defendant must have the intent, as I had stated before, the defendant must have the intent, or the defendant must show reckless conduct. For example, pregnant A walks towards the home and sees the smoke coming from the home's direction. And B meets A and tells A that your house is on fire and your husband is dead. Here, B will be liable to A for intentional infliction of emotional distress, because even though B did not have intent, yet his conduct was reckless. Thus, even if the act is not intended, but if the act is substantially certain to cause severe emotional distress, the defendant can be held liable for reckless conduct. Now let's take a look at bystander cases. You see, when the defendant intentionally causes severe physical harm to third person or third party, and the plaintiff, who is just a bystander, suffers severe emotional distress, this one can also be intentional infliction of emotional distress. Here, the plaintiff can sue the defendant if the present relative knew that the plaintiff was present when the injury occurred to the third party. The plaintiff is also a close relative of the injured third party, and the defendant knew that the plaintiff is present and is close relative of the injured third party. Here, note that it is not necessary for the plaintiff to establish the presence or the relation to the injured third party, so long the plaintiff can prove that the defendant had a design, an intent, or a purpose to cause severe distress to the plaintiff. And also remember that in the case of intentional infliction of emotional distress, the plaintiff must prove actual damage. Now let's take a look at false imprisonment. false imprisonment. You see, false imprisonment is also another type of intentional tort. It is an intentional tort that provides the plaintiff or the target individuals or the injured party with a civil remedy against those who unlawfully deprive them of their freedom of movement. Here, the plaintiffs must prove that they were intentionally and unlawfully detained against their will for an unreasonable period of time. So, intentionally and unlawfully detained against their will for an unreasonable period of time. And most courts, however, have held that plaintiffs must be aware of their confinement while suffering it, or if not, they must suffer some type of actual harm. Now we will be taking a look at intentional torts against property. Intentional torts against property. So just as intentional torts may be committed against a person, you see intentional torts may also be committed against the property. And we will now be taking a look at some of the common ones. Trespass. You see there are two types of trespass. Trespass to land or trespass to real property or realty, and trespass to chattels or trespass to personal property. Trespass to land is the intentional and unauthorized invasion of real property. The relevant intent for this claim is the intent to enter the property. So a person who unknowingly crosses from his own property to an adjacent plot may be liable for trespass, even if he did not know that the land belonged to another. Trespass to land also, remember, that may occur when a person or object such as a litter, it enters the property. Thus, the trespass to land occurs so long as there is intentional entry onto the land of another. It is irrelevant if the defendant or the tortfeasor unknowingly entered or not. Entry here includes also remaining unlawfully or entering a part of the property that the defendant has no permission to enter. And note that such entry can be done without any physical object, even if not is by a person. Also remember that such breach extends to reasonable airspace above the ground and to the center of the earth or the downward direction. So when we look at the elements of trespass to land, it's basically a physical invasion of a real property, for example, a land. The act must interfere with the plaintiff's exclusive possession to land, and there must be an intent to bring about the invasion, and there must be a possession. So there are two ways to commit physical invasion. First is to go physical into the property. You see here the defendant does not need to know that he has crossed the boundary line, and there need not be actually a physical boundary line. Or throwing something into the plaintiff's land. For example, throwing a stone to the plaintiff's land. It means that is throwing something. This something must be tangible. For example, shining light into plaintiff's land, or playing loud music, or the fumes are wafting into plaintiff's land. These are not trespass. Why? Because these are not tangible. Sight, sound, smell. There is no physical invasion. There is no physical invasion. So, is this a tortious act? Yes, this is still a tortious act because this is nuisance, which we will be discussing after some. And also remember, like I said earlier, the defendant need not physically enter the land. For example, just throwing rocks onto the plaintiff's land is enough to constitute a trespass to the land. And the trespass may also arise if the defendant is present on the plaintiff's land after the lawful right of entry or the presence has occurred. Here, there are a few things to note. First is that it's not considered a trespass if there is no entry or no invasion. In that case, nuisance or strict liability may be considered. And if there is no intent and no trespass, for example, someone has pushed the defendant and the defendant falls into the plaintiff's land, there is no trespass. Or the defendant rides a horse and the horse panics and gallops into plaintiff's land. Or sleepwalking into the plaintiff's land. There is no intent. Therefore, there is no trespass. And here remember that land means surface above as well as below the. What about mistake? You see, mistake as to the lawfulness of entry is irrelevant. Intent to the trespass is not necessary. Just the intent to enter is enough. intent to enter itself is enough to constitute trespass. And even also intent to harm is not necessary to constitute trespass. Intent to enter is enough to constitute trespass to land. So who may bring action? You see, one who is in possession may bring action of trespass. And this may include the lessee, who can recover to the extent the trespass damages the leasehold interest. What about the defenses? See, when we think about defenses to trespass to land, there are two kinds. One is private necessity, one is public necessity. Private necessity is basically an emergency and it is a defense to the trespass, but defendant may still be liable for compensatory damages, that is, any damages that have been to the land. For example, to avoid the charging bull, the defendant jumps over the fence and trespasses the plaintiff's land and tramples over the plaintiff's prized petunia flower. Here, the plaintiff cannot force the defendant to get off the land so long the necessity exists. That is, the charging bull is still outside the fence. And if plaintiff forces the defendant to get off his land and the defendant is injured by the bull, here the plaintiff will be liable. But the plaintiff can always sue the defendant for compensatory damages because the defendant has damaged his prized flower. What about public necessity? You see, public necessity is also an emergency and it is a defense to trespass, and the defendant will not be liable for the damage to the land. And when we think about public versus private necessity, you see, when the defendant tries to save himself or a family or one member of the community, it is a private necessity and it is a qualified defense. And public necessity arises when the defendant, let's say, trespasses to save many members of the community. He has absolute defense. And with regard to trespass to land, it is not necessary to prove actual damages or injury in trespass to the land. What about trespass to chattel? Trespass to chattel. You see, trespass to chattel is an intentional interference with a plaintiff's right of possession to personal property. This may occur if a defendant damages the personal property or deprives the plaintiff of possession of the personal property. And personal property can include any kind of movable property, which includes car or pets, etc. That is everything that is not intellectual property or real property or a service. And this interference with the personal property could be in the form of a theft, damage, or even simply depriving the owner of the power to use it lawfully. So when we think about trespass to chattel, let's look at the elements. Basically, any act of interfering with the plaintiff's right of possession in the chattel. So anything movable and tangible, that is personal property that belongs to the plaintiff. For example, car, dog, headphones, computers, etc. Everything tangible except for immovable properties such as land or building. And there must be an intent to perform an act that brings about the interference. There must be a causation and there must be damages. And damages, it means it must be proved by the plaintiff, and in such a case, the cost of repair of the chattel can be recovered. And also remember here a few things to note is that the trespass to chattel is always there is a cause of action for vandalism or theft of personal property. And when we think about interfering, it means damaging, dispossessing, breaking, scratching, erasing, etc. And even stealing. And mistake as to lawfulness of action is not an excuse. An intent to do an act of interference with the enjoyment of that property of another is enough. Who may bring the action? Anyone who has possession or immediate right of possession of the shackles may bring an action. And when we talk about trespass to shackle versus conversion, we'll be discussing about conversion later in today's class. You see, in an action for conversion lies in case when the interference with the shackle is of a serious nature
the defendant must pay the full value in damages. And if the interference is of a less serious nature, is considered a trespass to the chattel. And in the case of trespass to chattel, always remember that actual damages must be proved. That is, dispossession must. Now let's take a look at nuisance, which is another type of intentional torts against property. Nuisance, intentional torts against property. A nuisance is a reasonable and let's say a substantial interference with the use and or enjoyment of the land that does not involve a physical trespass. And nuisances may be considered as private or public nuisance. A private nuisance, it intrudes on a person's use and enjoyment of his land. Whereas a public nuisance, it intrudes on the public comfort or the peace or health or safety of the community. In a nuisance lawsuit, the courts will weigh the utility of the activity causing the nuisance and the burden of preventing such a conduct against the nature and severity of the harm. So when we think about the definition of nuisance, you see it is basically a substantial and unreasonable interference with peace, use, or enjoyment of his property. For example, being inconsiderate, shining bright light on a neighbor's property at night, or playing loud music in middle of the night, etc. These are all instances of nuisance. However, living near the church and the church is ringing the bell every hour is not a nuisance. And when determining whether a certain act is a nuisance or not, the court will do a balancing test. That is, the court will weigh the utility of the defendant's conduct versus the gravity of the harm caused to the plaintiff. And if the utility outweighs the harm, there is no injunction, but damages may be allowed. And if the harm outweighs the utility, even injunction will be allowed. And when we think about private nuisance, it means there must be a substantial unreasonable interference with the plaintiff's use or enjoyment. And when we think about nuisance versus trespass difference, you see in the case of nuisance is an interference with peace, the plaintiff's use or enjoyment, versus in the case of a trespass, it's an interference with the plaintiff's exclusive possession of the property. And what about public nuisance? It's basically an interference with the health, safety, or property rights of the community as a whole. For example, plaintiff trips over an object maintained by the defendant on the sidewalk. Now let's discuss about conversion. You see, conversion or the tort of conversion is similar to the tort of trespass to chattel, as they both require a defendant to interfere with another person's right of possession in personal property. And likewise, the defendant must have intended to exercise control over the property in a manner which is inconsistent with the owner's right. And it is not required that the defendant know that the property belongs to another. However, for conversion, the interference must be so serious in terms of duration and extensiveness of the purpose that it warrants that the defendant pay the personal property's full value. So when we think about conversion, we can think of it as same as trespass to chattel, but of a more serious nature of tort. So if we have to think about the element, we can say that conversion is an act of interfering with the plaintiff's right of possession in the chattel. There must be an intent, there must be a causation and damages. And these damages must be proved, and full fair market value of the chattel at the time of conversion can be recovered. In the case of conversion, we can say it's kind of a forced sale. You break it, you bought it. And when we talk about subject matter of conversion, it can be tangible personal property and intangibles, which is reduced to physical form. For example, a promissory note and documents in which the title to the chattel is merged. For example, a warehouse, but not bakery route or customer list or business good. What are considered to be acts of conversion? Well, it can be a serious invasion of the plaintiff's chattel, for example, a wrongful acquisition, that is theft, embezzlement, etc., or a wrongful transfer, that is selling, misdelivery, pledging, or a wrongful detention, that is refusing to return to the owner, or it can be a substantially changing, severely destroying or damaging or serious misuse. These are the words that is used to describe conversion. Remember that in the case of conversion, mistake is not an excuse. And also in the case of conversion, the intent to perform the act of interference is enough. And even for a bona fide purchaser for value, he may also be liable for conversion. Accidental damage or the loss to the plaintiff's chattel, however, does not amount to conversion unless the defendant was using the chattel without the permission of the plaintiff when the accident had occurred. What about stolen goods? You see, if the bailee receives goods from the thief without knowing that those are stolen goods, he may return the goods to the thief without being liable to the true owner. However, if the bailee knows that those are stolen goods and the real owner makes a demand for those goods, the bailee will be liable to the owner if he returns the goods to the thief. And who can bring an action in a conversion? Anyone who has possession or immediate right of possession of the chattel. And what about remedies? In the case of conversion, there can be damages. The plaintiff can claim damages, that is the fair market value as of the time and place of the conversion. The plaintiff can ask for replacement, that is recovery of the chattel. And in the case of conversion, also remember that actual damages, that is dispossession, needs to be proved in action for conversion. Next, we will take a look at trespass to personal property or a chattel versus conversion. The difference. You see, here we need to look at the differences between trespass to personal property or chattel and conversion. When the damage and or the interference is less severe, this tort is called trespass to personal property or chattel. And the only remedy that the plaintiff has is to recover the value of the damage done to the property. However, when the damage and or the interference is so severe that it warrants a forced sale, then it is then called a conversion. And in such a case, at the plaintiff's option, the defendant can be forced to pay for the entire property or the object. And the defendant obviously will get to keep whatever is left of the object. So here you can see some differences between trespass to chattel and conversion. For example, hitting a dog and slightly injuring it can be considered to be trespass to chattel, but hitting a dog and killing it is considered as a conversion. Or let's say breaking a windshield of a car by an errantly thrown ball is a trespass to a chattel, but totaling a car by smashing into it with a hammer while it is parked is a conversion. Or keying someone else's car is a trespass to chattel. However, hot wiring someone else's car and driving away in it is a conversion. Or using someone else's pencil to write, let's say, 3 sentences is a trespass to chattel. But cracking someone else's pencil is a conversion. So these are the differences between trespass to personal property or chattel versus conversion. Now, we will take a look at intentional torts against economic interest or economic torts. You see, these intentional torts, that is economic torts, these are not committed against person or property. Instead, the harm done is to intangible assets such as economic interest or the business relationship. We will now take a look at some of the most common forms of economic tort. First is fraudulent misrepresentation. You see, fraudulent misrepresentation, also known as, let's say, fraud or deceit, it protects the economic interest and the right to a fair and honest. For a fraud claim, a plaintiff must establish that the defendant intentionally misrepresented a material fact and the plaintiff relied on and was harmed by the misrepresentation. For example, let's say if a business submits materially misleading financial statements to a bank in an attempt to secure a loan and the bank, relying on such statements, lends the money to the business. The bank will have a fraud claim against the business if the business later defaults on the loan. A fraud claim may also arise from the failure to disclose a material fact if the defendant had owed a duty to speak on account of a special relationship. For example, a financial advisor representing both a buyer and seller of real property may be liable for fraud if he knows that the property contains toxic chemicals and he fails to inform this to the buyer. What about interference with contractual relations? This is the second type of economic tort. Interference with contractual relations. It is a tort of interference with contractual relations. It permits a plaintiff to recover the damages based upon a claim that the defendant has interfered with the plaintiff's contractual relations. Here, the elements of an intentional interference with contractual relations claims are: number one, there must be a valid contract between the plaintiff and the third party. Two, the defendant's knowledge of this contract. Three, defendant's intentional acts designed to induce a breach or disruption of this contractual relationship between the plaintiff and a third party. Four, the actual breach or disruption of the contractual relationship. And five, a resulting damage. To be considered a tortious, a defendant's action must therefore substantially exceed the fair competition and free expression, such as, let's say, persuading a bank not to lend a competitor any money. Next, interference with prospective business advantage. The tort of interference with prospective business advantage, it protects the economic interests that have not yet been formalized into a contract. The elements of that tort are what? They are: number one, that the economic relationship between the plaintiff and some third person containing the probability of future economic benefit to the plaintiff. Two, the defendant's knowledge of the existence of that relationship. Three, the defendant's intentional acts that are designed to disrupt that potential relationship. Four, actual disruption of that relationship. And five, damages that has been caused to the plaintiff are the approximately caused by the acts of the defendant. Next is unfair competition. What is unfair competition? You see, the acts of competing with another not to make a profit, but for the sole purpose of driving the other party out of business is known as unfair competition. And in California, the tort of unfair competition includes any unlawful, unfair, or fraudulent business act or practice, and unfair, deceptive, untrue, or misleading advertising. These are known as unfair competition. And there are also some other forms of economic torts. These are theft of trade secret or proprietary information that the companies typically will seek to protect. The trade secrets are confidential information that provide a business with a competitive edge over other businesses in the same industry. And they are usually defined broadly and can include anything from commercial secrets to manufacturing or industrial secrets. For example, the recipe of Coca-Cola is probably one of the most famous and well-kept trade secrets. And theft of a trade secret occurs when a person using confidential business information without authorization. And depending on the laws of a particular jurisdiction, the trade secrets can be protected by intellectual property or by unfair competition. And next is trade libel. What is trade libel? This is trade libel, which is a form of defamation unique to business organizations in which a company suffers financial loss from the publication of untrue statements. Thus, trade libel, we can say it's a type of defamation that is specific to businesses only. The elements of a trade libel case are very similar to the elements of general defamation, but there are some differences. The elements of a trade libel case are basically: first, the defendant must have made a false statement about the quality of the plaintiff's products or services. Second, the statement must have been published. And third, the plaintiff has suffered monetary loss or harm as a result of the statement. And then, what is commercial disparagement? You see, commercial disparagement or business disparagement, which is a form of defamation applicable to business organizations in which a false and a damaging statement about a business is published. And this occurs when derogatory statements are made about a person's business or a person's title to his or her property with the purpose of discouraging others from dealing with the person. And business or commercial disparagement is very broad. Remember, it's very broad. And it covers statements about a business being dishonest, unethical, or incompetent. And this type of business tort, it exists to prevent unfair competition between the businesses. It can also be brought against the customer. And remember that in order to prevail on a claim for business or commercial disparagement, a plaintiff must prove certain elements. And these are: first, a false statement is published; second, with the intent or reasonable belief that the statement will cause financial loss for the business; third, there is in fact a financial loss caused to the business; fourth, the defendant has made the statement knowing that it is false or with reckless disregard of whether the statement is true or false. Okay, now we will take a look at intentional torts against person, property, and business, the definitions and the remedies. From this chart, you can see the various various types of intentional torts, the definitions, and the remedies, that is the compensatory damages that are usually awarded in each of these different type of intentional torts. For instance, in the case of assault, the plaintiff can ask for, and the plaintiff can generally recover compensatory damages for medical bills, lost wages, and pain and suffering. And the same goes for battery also. And in the case of defamation, it can be a measurable financial loss. Or in the case of conversion, the compensatory damages can be for the full value of the converted item. Or let's say in the case of unfair competition, the damages can be for lost profits. Or in the case of disparagement, it can be for actual economic loss. So you can see here that for each of these different type of intentional torts against person, property, or economic interest, the law has specified on what basis, or for rather what, the plaintiff can be claiming the compensatory damages. Now next we will move on to negligence. So negligence is one of the most important topics of tort law. So when we talk about negligence, we have to carefully look at the elements of negligence first. So we said that a tort of negligence has occurred, or the defendant is liable for the tort of negligence. The defendant owes a duty to the plaintiff to conform to specific standard of conduct, and the defendant has committed a breach of that duty, and there is a causation, that is the breach was actual as well as the proximate cause of the plaintiff's injury, and there are damages, that is there have been actual damages caused to plaintiff's person or his property. So these duties owed to whom? And these duties owed to any foreseeable person, including the rescuer, but not the police or the firefighter, or any intended beneficiary of the economic transaction. However, note that the defendant has no duty to any unforeseeable victim. And however, unforeseeable person may also bring an action if that person is within the zone of danger, that is near the incident. So what is the applicable standard of care here? So when we think about the applicable standard of care, there are two types. First is the basic or the default standard of care, which is the objective standard, and that is the ordinary and reasonable standard of care should be exercised. That is from the perspective of a prudent person, that is a model citizen acting under similar circumstances. And the defendant will be held liable to the standard of a reasonable person. And it does not matter actually if the defendant is a minor or intoxicated or mentally ill, or the defendant has low IQ, etc. And the second is the objective standard, That is, when we think about objective standard, it means that the physical characteristics should be same as the defendant. When we talk about this reasonable person, the physical characteristics should be same as the defendant. That is, the average mental capacity or the same knowledge should be as that of the average member of the community. For example, let's take an example. If the defendant is healthy, then we assume that the reasonable person should also be healthy. And if the defendant is blind or lame, the reasonable person is blind or lame. Or if the defendant is intoxicated, mentally ill, or has low IQ, the reasonable person, however, in this case, need not be mentally ill, intoxicated, or low IQ. And if the defendant is a minor, the reasonable person is a minor. But if a defendant is a minor carrying out an adult activity, the reasonable person standard will be that of an adult. And the second type of standard of care is the subjective standard or the particular standard of care. And this is applied in the case of professionals, for example, doctors, lawyers, accountants, architects, etc. And this usually takes place in the case of malpractice actions. That is the negligence claim brought against the professionals. In this kind of a case, the professionals are expected to exercise the same care as the average member of the same profession nationally or follow the custom of the profession. It is the empirical standard. For instance, the doctors has a duty to disclose a material risk before a surgery. And if it is a risk that a patient would want to know, and if the doctor does a surgery and there is a lack of informed consent, then the plaintiff can recover against the defendant doctor. How about children? You see, below the 5 years of age, children are not expected to have a duty of care, and there is no liability for negligence for children who are below 5 years of age. For 5 years of age to 18 years of age, the reasonable we take it from the perspective of a reasonable child of a similar age and of a similar experience, and the intelligence acting under similar circumstances. That is, we follow the subjective standard of care. However, there's an example. See, children who are engaged in adult activity, for instance, a motorized vehicle, that is driving a car or a truck, a tractor, motorboat, snowmobile, or an airplane, the child will be required to conform to the same standard of care as a reasonable adult person and not a child, reasonable adult person. That is objective standard. And in the case of common carriers and innkeepers also, we expect a very high degree of care and they will be liable for the slightest of negligence. You see, personal injury claims are frequently based on a negligence claim. Negligence is a conduct that falls below a reasonable standard of care for the safety of those around you. A key difference between an intentional tort and a negligence claim is the actor's state of mind. A person who is negligent did not intend to cause harm, but they are still held legally responsible because their careless actions has injured someone. And four things together must come together to determine negligence. And a negligence lawsuit will succeed only if the plaintiff can prove all of the four elements. And what are those? We already discussed them. Their duty of care, the breach of that duty of care, and we must prove that the defendant has caused the plaintiff's loss and the plaintiff has suffered damages. Therefore, we can say that a tort of negligence is a failure to behave or act with a level of care that someone of ordinary prudence would have exercised under the same circumstances. And the behavior usually consists of actions, but can also consist of omissions when there is some duty to act. For example, a duty to help the victims of one's previous conduct. And primary factors to consider in ascertaining whether a person's conduct lacks reasonable care are the foreseeable likelihood that the person's conduct will result in a harm, and the foreseeable severity of any harm that may ensue, and the burden of precautions to eliminate or reduce that risk of harm. And remember that negligent conduct may consist of either an act or an omission to act when there is a duty to do so. So how do we when we are thinking about negligence, when we're discussing about negligence, the question comes to mind is how do we determine a breach? You see, when determining how or whether the defendant has breached a duty, the courts will usually use something known as the Hand formula that was created by Judge Learned Hand in United States versus Carol Towing. Here it says that the burden of taking the precautions, if the burden of taking the precautions is less than the probability of loss and the gravity of loss, then there will be a negligence liability for the party with the burden of taking the precaution. Again, if the burden of taking such precautions is less than the probability of the injury multiplied by the gravity of any resulting injury, then the party with the burden of taking the precautions will have some amount of liability. How do we determine now whether there was a duty to act? You see, typically if the defendant had a duty to act and did not act, that is resulting in a breach, and that breach has caused an injury, the defendant's actions will be classified as misfism. And there are several ways to determine that the defendant has a duty to act. However, what I'm about to discuss now is not an exhaustive list. So, number one, the defendant has engaged in the creation of the risk which has resulted in the plaintiff's harm. Or two, there's a voluntary undertaking, that is the defendant volunteered to protect the plaintiff from the harm. Or knowledge, number three, the defendant knows or should have known that his conduct will harm the plaintiff. Or four, a business or a voluntary relationship, for example, business owner and customer, innkeepers and guests, land possessor who opens a land to the public, or a person who voluntarily takes custody of another person. Now, how do we determine whether there was an injury? You see, typically, in order to meet the injury element of a prima facie negligence case, the injury must be one of the two things. And what are those? Number one, there must be a bodily harm, or two, there must be a harm to the property. It can be a personal property, or it can also be a harm to a real property. And note that in negligence cases, pure economic loss will usually not meet the injury requirement. Sometimes emotional distress or harm may meet the bodily harm requirement, even though if there is no accompanying physical harm. Next, we will be taking a look at some of the doctrines in favor of plaintiff in negligence actions. First, we will take a look at res ipsa loquitur. You see, a plaintiff has the burden of proving that the defendant has been negligent, and the plaintiff has to prove all the four elements of a negligence case. And sometimes, in fact, often it is not easy for the plaintiff to do that, because you see, direct evidence of negligence is often not available. For instance, let's say that a plaintiff is shopping in a supermarket and then she suddenly slips on a puddle of water near the frozen food section and injures herself. You see, there are no witnesses who saw her slip and fall. The supermarket staff helps her get back on her feet, and then someone comes and cleans up the puddle. The plaintiff has no clue here of who has caused her injury, except for the fact that she saw that the puddle of water had originated from the freezer. Can the plaintiff in this case claim any damages, even though she does not have any direct evidence that the supermarket, that is the defendant, had notice of the water and was negligent? You see, because of cases like this, two doctrines have been adopted by the courts to aid the plaintiffs in establishing negligence claims. What are these? These are res ipsa loquitur and negligence per se. Res ipsa loquitur is something that we will be discussing first. You see, res ipsa loquitur, in Latin, it means the thing speaks for itself. In tort law, a principle that allows plaintiffs to meet their burden of proof with what is in effect circumstantial evidence. The plaintiff can create a rebuttable presumption of negligence by the defendant by proving that the harm would not ordinarily have occurred without negligence, that the object that caused the harm was under the defendant's control, and that there are no other plausible explanations. So to prove res ipsa loquitur negligence, the plaintiff must prove three things. One, the incident was of a type that does not generally happen without negligence. Two, it was caused by an instrumentality solely in defendant's control. And three, the plaintiff did not contribute to the cause. The plaintiff did not contribute to the cause. So you see, accidents happen all the time, and the mere fact that an accident has occurred does not necessarily mean that someone's negligence has caused it. In order to prove negligence in a personal injury lawsuit, a plaintiff must present evidence to demonstrate that the defendant's negligence has resulted in the plaintiff's injury. And sometimes direct evidence of the defendant's negligence does not exist, but the plaintiffs can still use circumstantial evidence to establish negligence. And circumstantial evidence consists, you see, of facts that point to the negligence as a logical conclusion rather than demonstrating it directly or outright. And this allows the judges and the juries to infer negligence based on the totality of the circumstances and the shared knowledge that arises out of human experience. So res ipsa is one type of circumstantial evidence that allows a reasonable fact finder to determine that the defendant's negligence has caused an unusual event that subsequently caused injury to the plaintiff. And this doctrine, you see, it arose out of a case a long time back when the plaintiff had suffered injuries from a falling barrel of flour while walking past a warehouse. And at the trial, the plaintiff's attorney had argued that the facts spoke for themselves. The facts spoke for themselves and demonstrated that the warehouse's negligence, since no other explanation could account for the cause of the plaintiff's injuries. And as it has developed ever since then, res ipsa, it allows the judges and the jury to apply common sense to a situation in order to determine whether or not the defendant had acted negligently. So what are the elements of res ipsa loquitur? You see, since the laws of personal injury and evidence are determined at the state level, the law regarding res ipsa loquitur, it varies slightly between the states. And that being said, you see, a general consensus has emerged and most states follow one basic formulation of res ipsa. And under this model of res ipsa, there are three requirements that the plaintiff must meet before a jury can infer that the defendant's negligence had caused the harm in question. What are these? First, the event doesn't normally occur unless someone has acted negligently. Second, the evidence rules out the possibility that the actions of the plaintiff or the third party has caused the injury. And third, the type of negligence in question falls with the scope of the defendant's duty to the plaintiff. So how does this res ipsa loquitur could work? Let's take an example. Suppose for a moment, let's say you are walking down the street next to a brewery when suddenly a giant barrel of yeast, it falls out of a window. And this barrel, it strikes you and you sustain severe head and spinal cord trauma. There was a witness who saw the barrel fall out from the window, but they could not see what had caused it to fall. And now you decide to file a lawsuit against the brewery, alleging that the owner is liable for the injuries you have sustained. You see, in this incident, there is no direct evidence that the owner had caused the injury or that their negligence has caused the barrel of the yeast to fly out from the window. However, there is no other explanation of how the barrel had flown out from the window of the brewery and it crashed onto you. So this scenario meets the three elements of res ipsa loquitur mentioned just now. You see, it is not an incident that normally would occur unless someone has acted negligently. And the evidence ruled out the possibility that you caused the injury yourself or that a third party has caused the injury. And the brewery owner also had a duty to ensure that barrels do not fall out from the window and cause harm to others. Now we will also take a look at a real world example. We'll take a look at a real world example. Henry, are you there? Henry?
Joe, are you there?
Yes.
Joe?
Yes.
Yeah. Joe, can you read this case? Can you read this case law? It's about res ipsa loquitur.
Facts on September 27, 1998, the plaintiff and her husband, Michael Morris, were shopping in the defendant's same club when the plaintiff stripped and fell off on the substance thought to be water next to the small portable freezer known as the spot box. After four, some of the defendant's employees approached to lead the plea of assistance. At this point, the plaintiff noticed that her clothes were soaked in what she believed to be water from the nearby freezer. When the store manager arrived at the scene, he ordered the water to be cleaned up. He pointed out to the plaintiff and her husband that the plug in the bottom of the freezer was out. The plaintiff testified that the store manager additionally said testified. Said that the spot box was new and that he feared it might not be functions properly. As a result of her injury, the plaintiff was severely bruised and advised to stay in bed and off her feet for a week. The plaintiff subsequently filed suit against the defendant in Shelby County, Tennessee. The defendant removed the matter to district court on the basis of diversity of the sentencing. Following the plaintiff's case in chief, the defendant moved for a judgment as to law, arguing that the plaintiff failed to provide evidence that the defendant had notice of the water, and that the plaintiff could not rely upon the doctrine of res ipsa loquitur. The plaintiff argued that she was not attempting to and could not show notice. She claimed instead that she provided evidence that the defendant created a dangerous condition by placing the new spot box out without a plug in it, and that the doctrine of res ipsa loquitur applied. The district county granted the defendant motion. The plaintiff appealed. Issue: should the plaintiff be allowed to use res ipsa loquitur to recover from injuries suffered by a defendant's malfunctioning product? Reasoning: a plaintiff should be allowed to use res ipsa loquitur to allow the jury to infer negligence when the plaintiff can demonstrate two conditions. First, the plaintiff was injured by an instrumentality that was within the defendant's executive control. Second, the injury should not ordinarily have occurred in the absence of negligence. To satisfy the first condition, Tennessee's courts require that establishing executive control involves proving the defendant had a duty of care over the instrument that caused the harm. This standard should not be applied strictly because then the standard would become overly restrictive, instead showing that the negligence was more likely than not that of the defendant and not another person will satisfy this condition. The second condition would be satisfy the plaintiff proof that the injury more likely than not occurred because of some negligent conduct. This standard does not require all possible alternatives to be disproved. The defendant moved for judgment as to law, which requires the trial court to look at the evidence in the most favorable light possible to the non-moving party, the plaintiff. If a reasonable injury could find in favor of the plaintiff after evaluating all the evidence, then the trial court's granting of the motion was in error. In this case, the plaintiff provided evidence that the manager believed that the freezer was malfunctioning and subsequently wanted to move it from the public space. That the freezer did not have the plug properly installed, and that the substance that she slipped on was likely water emanating from the freezer. The evidence regarding where the liquid was from was corroborated by the plaintiff's written statement at the scene, as well as the testimony of the employee tasked with cleaning the liquid, who said that the water was about 10 inches in diameter and right there under the drain of the freezer. This evidence would be sufficient to allow a reasonable jury to find those elements of the re-expert locutor certified and the info negligence on the part of the defendant. Decision and the remedy. A count reversed the trial court's granting of the summary judgment in favor of the defendant and order a new trial at which re-expert locutor may be used.
Thank you. So you see, so this is a case that provides an illustration or an example of the types of condition that can lead a jury to infer negligence. Okay. Now we will be taking a look at negligence per se. This is the second doctrine. First one was res ipsa loquitur. The second one is negligence per se. What is negligence per se? It is basically negligence in itself. You see, it means negligence in itself. In a torts case, a defendant who violates a statute or regulation without an excuse is automatically considered to have breached her duty of care and is therefore negligent as a matter of law. And as a result, the only thing that must be proved at the time of trial is whether the violation was the cause in fact and the proximate cause of the plaintiff's injury. So a person, you see, is negligent per se if she violates a statute that is designed to protect against the type of accident or harm that is caused by her conduct, and the plaintiff is someone the statute is designed to protect. The most common application of negligence per se is the traffic violations, where the driver is automatically considered negligent and liable for violating the traffic code. So you see, there's exceptions where a person's violation of a statute is excused and not considered negligent. The exceptions include cases where the statute is unclear, or the person has exercised reasonable care in attempting to comply with the statute, or the person's non-compliance with the statute has resulted in less harm than if he had complied. And remember that a safety statute or regulation applies only if it is intended to protect the class to which the plaintiff belongs, and if it is intended to guard against the particular harm suffered by the plaintiff. For example, if a safety regulation is related to electricity and is intended to protect against the risk of workplace injury, but the plaintiff is an ordinary passerby and the plaintiff is injured by the electricity, that regulation may not be the basis for a negligence per se action. And this mere reasonableness of a defendant's action does not excuse him or her in a jurisdiction that follows traditional negligence per se rules. However, you see, there are situations that can give rise to a defendant's legitimate excuse. And under the restatement second of tort, section 288A, certain excuses are permitted for statutory violations, even in states that generally follow negligence per se. And so what are these legitimate excuses? See, legitimate excuses include when a defendant's incapacity made it reasonable for him to violate the statute, or a defendant neither knew nor should have known of the occasion for compliance, or a defendant was unable to comply even using reasonable diligence or care, or the defendant was confronted by an emergency that was not caused by his misconduct, or compliance would have involved a greater risk of harm to the defendant or to others. Now, let's discuss a bit about the variations on negligence per se. You see, a few states, they follow variations on negligence per se. In some states, for example, the violation of a safety statute creates a presumption of negligence. However, the defendant, you see, can rebut that presumption in order to escape liability. In other jurisdictions, the statutory violation is merely an evidence of negligence, and the violation neither creates a rebuttable presumption of negligence nor firmly establishes negligence. And moreover, unlike with traditional negligence per se, a defendant in those states has the opportunity to prove the reasonableness of his or her actions, even though they did not meet the standards of the safety regulations or the statute. Now we'll take a look at the defenses to negligence. The defenses to negligence. What kind of defenses a defendant can come up with when he faces a negligence lawsuit? You see, to successfully defend against a negligence lawsuit, the defendant will try to negate one of the elements of the plaintiff's cause of action. In other words, the defendant will introduce evidence that he or she did not owe a duty to the plaintiff, or he has exercised reasonable care, or did not cause the plaintiff damages, and so forth. And in addition, a defendant may rely on a few doctrines that may eliminate or limit the liability based on the alleged negligence. The three most common doctrines that serve as a defense to negligence are contributory negligence, comparative fault, and assumption of risk. Let's take a look at them one by one. First is the contributory negligence and the last clear chance doctrine. You see, one of the most commonly used defenses to negligence claims is to show contributory negligence on the part of the plaintiff. Contributory negligence, it occurs when a plaintiff's conduct falls below a certain standard necessary for the plaintiff's protection, and this conduct cooperates with the defendant's negligence in causing harm to the plaintiff. In plain English, this means that the plaintiff most likely would have avoided injuries had he or she not also been negligent. For example, a factory worker suffers serious burns to his face after his welding torch malfunctioned. However, he had failed to flip down his mask before using a torch, which would have prevented the injury. So technically speaking, the plaintiff's negligence for his own safety, that is failure to use the proper safety equipment, is the cause in fact and the proximate cause of the damages. And some states, including the District of Columbia and North Carolina, they use the doctrine of pure contributory negligence. And under this doctrine, a victim who is only 1% at fault may be denied compensation in a lawsuit. Indiana, meanwhile, applies this doctrine only to malpractice cases. An exception to the contributory negligence defense is known as the last clear chance, when the defendant could have avoided causing injury by using ordinary care. For example, A pedestrian crosses the street even though the don't walk sign is clearly visible. And a motorist who has the right of way but is distracted by a cell phone strikes and injures the pedestrian. Since the motorist could have avoided striking the pedestrian had she used ordinary care, the motorist can still be found liable. And in many states, contributory defense to negligence claims and by extension the last clear chance exception has been replaced by comparative negligence. So that brings us to comparative negligence. You see, the doctrine of comparative negligence reduces a plaintiff's recovery by the percentage in which the plaintiff is at fault for his or her damage. A majority of states have modified this rule, barring a plaintiff from recovering if the plaintiff is as much at fault in some states or more at fault in some other states than the defendant. So there are three main types of comparative negligence. You see, they are pure comparative negligence. That is, plaintiff is awarded a percentage of the damages for which the defendant is responsible, or modified comparative negligence. That is, the plaintiff is awarded damages only if his or her negligence is equal to or less than the defendant's negligence. And third one is the slight gross comparative negligence. That is, the plaintiff is awarded damages only if his or her negligence is considered slight and the defendant's negligence is gross. So, for example, let's say a drunk driver strikes and seriously injures a pedestrian, failed to use a nearby crosswalk. So, although it is unlikely the defendant or the driver would have acted any differently had the pedestrian used the crosswalk, the driver's or the motorist's civil liability may be reduced due to the plaintiff's own negligence. And it is good to know that New York is one of the 13 states that operate under a pure comparative fault law. This means that each party involved in a personal injury lawsuit in New York has the opportunity to recover the compensation, even if one party is 99% at fault and the other party is 1% at fault. And the third defense to negligence claim or negligence lawsuit is assumption of risk. You see, when a plaintiff voluntarily assumes, that is, the plaintiff is aware of the risk involved in an obviously dangerous activity but proceeds to engage in that activity anyway, he or she may not be able to recover damages for the injury. In order, you see, for this doctrine to apply, the plaintiff must have actual and subjective knowledge of the risk involved in the activity. The plaintiff must also voluntarily accept the risk involved in the activity. And this assumption of risk defense would not apply to any additional unknown danger. An example, let's take an example. An example may involve an amusement park ride that flips the passengers completely upside down. A passenger who saw the ride and knew what would happen on the ride assumed the risk associated with the ride. On the other hand, a plaintiff does not assume the risk of something unexpected related to the ride, such as where a loose bolt causes the ride to throw the plaintiff into the air in a violent manner. Also remember that this assumption of risk may be express or implied. Under the express assumption of risk, the persons agree in advance that one person consents to assume the risk of the other's negligence. For example, a skier who purchases a lift ticket to a ski resort usually expressly agrees to assume the risk of any injury that might occur while skiing. Thus, even if the ski resort negligently fails to mark a hazard on a trail resulting in an injury to a skier, the ski resort may involve the assumption of risk defense in the skier's subsequent lawsuit. Also remember that assumption of risk may also be implied from a plaintiff's conduct. For example, the defendant gives the plaintiff, let's say a painter, a scaffold with a badly frayed rope. The plaintiff, fully aware of the rope's poor condition, proceeds to use the scaffold, the rope breaks, and then the plaintiff is injured. The defendant can raise the implied assumption of risk defense here. And you see, this defense is similar to the contributory negligence defense. And in this example, the defendant might also argue that the plaintiff was contributory negligent for using the scaffold when he already knew that the rope was frayed. And the implied assumption of risk defense has caused a great deal of confusion in the courts because you see of its similarity to contributory negligence. And with the rise of comparative fault, the defense has diminished in importance and is viable today only in a minority of jurisdictions. And you see, there are also other special defenses to a negligent claim or a negligent lawsuit. And many states, in fact, have additional ways to defend against the claim of negligence. For example, you see, laws in some states hold that people in peril or people in danger who receive voluntary aid from others cannot hold those offering aid liable for negligence. And these laws, commonly called Good Samaritan statutes, they attempt to encourage selfless and courageous behavior by removing that threat of liability. And the defendant, you see, in a negligence suit can also avoid liability by establishing a superseding cause. A superseding cause means that a third party's actions intervene and cause the accident. In other words, an unforeseeable or improbable intervening cause will constitute a superseding cause and will allow a defendant to escape liability. And let's say a person is getting off a bus in a parking lot. Meanwhile, the driver of a nearby car puts her vehicle in reverse and runs over the person who just got off the bus. The bus passenger who got injured sues the bus company for failing to provide a safe place for passengers to get down or disembark. But you see, in this situation, the action of the car driver may be considered a superseding cause of the passenger's injuries, whether or not the bus driver could be considered negligent. And in other words, in a personal injury lawsuit filed by the injured passenger against the bus company, the company will point to the car driver's negligence as a superseding cause of the bus passenger's injuries. And it's also important to take a look here at the difference between superseding and intervening cause. Sometimes you see intervening cause may also play a role in causing the plaintiff's injury and disrupt the so-called causal chain and can diminish or even wipe out the defendant's liability. And what do we mean by intervening cause? You see, if after the defendant acts negligently towards the plaintiff, a new cause combines with the defendant's negligence to contribute to or worsen the plaintiff's injury, that new cause is sometimes called an intervening cause. So a key part of this definition here is that the intervening cause has to occur after the defendant's negligent action or inaction. And intervening cause can be the action of another person, which is also called a third party. It can also be the act of nature, such as a branch falling off a tree or a weather-related event. And the original defendant will usually still be considered at least partially liable for the plaintiff's injury, even when an intervening cause is said to exist. And this is the biggest difference between an intervening cause and a superseding cause. In contrast to an intervening cause, which does not relieve the original defendant of liability, a superseding cause usually does relieve the original defendant of liability. In other words, a superseding cause is an intervening act that is legally sufficient to transfer the blame for the harm in question from the defendant to the third party or to a natural event. And when we discuss this, we can understand that it usually therefore comes down to the concept of foreseeability. You see, the key difference between an intervening cause and a superseding cause is foreseeability. And intervening act will be called a superseding cause or a superseding act that relieves the original defendant of liability when that intervening act was or should have been reasonably foreseeable to the original defendant. And let's take an example to understand this better. Let's say that a homeowner digs a hole into a sidewalk and negligently leaves it open without any warning to pedestrians. A fellow pedestrian now negligently fails to leave enough room for the plaintiff to pass on the sidewalk, and the plaintiff falls into the hole. And under the long-standing premises liability standards, the homeowner is almost certainly negligent for leaving an open hole in the sidewalk. And the fact that the second pedestrian was also likely negligent for crowding the plaintiff into the hole. So the second, pedestrian can also be found liable for negligence. So the second pedestrian action here, you see, it was an intervening act. But was it a superseding act? The answer is probably no, because the intervening act was or should have been reasonably foreseeable to the homeowner. Why? Because if you leave an open hole in a sidewalk, it's reasonable to foresee that someone will fall into it, especially if the sidewalk is crowded. Now we will discuss about the concept of strict liability. Strict liability. You see, in tort law, strict liability is the imposition of liability on a party without a finding of fault, such as negligence or a tortious intent. And the plaintiff need only to prove that the tort has occurred and that the defendant was responsible. This law of strict liability imputes and it is considered in situations that are inherently dangerous. And it is a legal doctrine. It's a legal doctrine that holds a party responsible for their actions or products without the plaintiff having to prove negligence or fault. And when someone, let's say, partakes in an ultra-hazardous activities such as keeping wild animals, using explosives, or making defective products, then they may be held liable if someone else is injured. And even if the defendant has taken all the necessary precautions and followed all the safety requirements, strict liability are usually unique in that they would still be holding the defendant responsible. And due to the nature of the activity, the defendant should be able to foresee that the person would be harmed by it. You see, the main categories of strict liability includes, for number one, as you can see here, keeping wild animals. Anyone who keeps a wild animal will be held responsible for any harm that the wild animal may cause to another person. Second is ultra-hazardous activities. What are these? So activities such as transporting, let's say, volatile chemicals and using explosives or fireworks, these are considered strict liability by the court when someone is injured. Third is consumer product liability. You see, if a product is defective and causes injury and makes the product dangerous, the manufacturer or seller of the product will be liable under strict liability. And while these categories, you see, may be different, there is a shared theme. You can see a shared theme between the three categories. You see, in all the cases, the categories are dangerous and require a high degree of responsibility by the defendant. And for instance, owning a wild animal means that the owner has assumed a special level of responsibility, knowing that a wild animal is inherently dangerous. And in the case of ultra-hazardous activity like blasting or using explosives to blow large amount of rock or earth, is clearly also dangerous and is often conducted by professionals who has to learn how to handle and use something so dangerous. And in the case of a product manufacturer, you see, a product manufacturer has a unique position of earning and keeping the public trust. And in the eyes of the law, they have set themselves up to create and sell a product that users should be able to trust and not worry about being injured or being dangerous. So a manufacturer who betrays the trust and creates an item that is dangerous, even unintentionally, and that item injures a consumer, such a manufacturer would be held liable. And you see, while these categories may be different, as I said, there's a shared theme. And what is important to know here is what must the plaintiff then prove to win. You see, in order to win a strict liability lawsuit, the plaintiff must show the following. What are these? First, there are three things the plaintiff must show. First, the plaintiff must show proof of the injury. Second, the plaintiff must prove that the defendant's action or product has caused the injury. And third, the plaintiff must show that the defendant's activities were unreasonably hazardous or abnormally dangerous, or that the defendant had control over the product. And this begs the question, when are the manufacturers not liable for product-related injuries? You see, in some unique cases, a manufacturer may not be held fully liable for product injuries due to the chain of supply. For example, a baby food company, and which is in fact one of the most strictly regulated manufacturing industries, creates a formula. And these companies safely package and ships the formula, and the formula is safe to eat without any danger. But when the retail store stocked that formula, they put it away in an environment where it was badly damaged, torn, and infected with botulism or other harmful substances that make the baby formula deadly. If it is clear that this baby food manufacturer did not make any mistakes and that their product was safe to consume, and that the store's error in stocking the product had caused the illness, then the store will be most likely be held liable and not the manufacturer. So in this case, the retail store would rather be held liable and not the manufacturer. Ultimately, you see, manufacturers who exhaust all the measures to ensure the safety of their products, as well as forewarn the customers or the consumers of any dangers associated with their products, they may limit themselves from potential liability. And it's also important to know something about animal bites. How does strict liability play in the case of animal bites? You see, in some jurisdictions, the theory of strict liability is also used in connection with pets or animals that bite or attack, animals that bite or attack. And the reason for strict liability in those jurisdictions is that the animals do not have a conscience, and those who choose to keep them as pets have a duty to restrain them to avoid harm to others. And often state laws, you see, they recognize a difference between domesticated and wild animals. In many jurisdictions, a person who keeps domesticated animals will be strictly liable for injuries only if the pet owner had actual knowledge of the pet's dangerous propensities. The pet owner had actual knowledge of the pet's dangerous propensities. However, in some states or localities, a statute or ordinance has been passed such that the dog owners or the pet owners can be held strictly liable for damages caused by their animals trespassing on somebody else's property. And you see, where the animal in question are of a species that can be domesticated, ordinary negligence rules apply unless the owner knew or should have known that the animal has dangerous or vicious properties. For example, if the domesticated dog engages in attacks on people, while the initial attacks might be subject to ordinary negligence analysis, the later attacks will subject the owner to strict liability because the owner should have known that this particular animal is dangerous, or in other words, this animal has vicious or dangerous propensity. And this rule is sometimes known as the one free bite rule, based on the idea that the first bite is not subject to strict liability. However, as I said earlier, the owner may still be subject to liability if the owner was negligent. And what happens when wild animals are involved? You see, when wild animals are involved, the keeper of the wild animal will be held strictly liable even if the animal is not known to be dangerous. Because wild animals can be vicious and unpredictable, keeping them is considered an inherently dangerous activity. And by doing so, the keeper of the wild animal is implicitly taking upon himself the risk of liability should the animals cause any injury. And now remember that a wild animal is an animal that belongs to the category of animals that have not been domesticated and are likely to cause personal injury if not restrained. So for instance, snakes, lions, and bears, these are classic examples of wild animals. And if a person harbors or keeps a wild animal, even legally, then liability for injuries inflicted by the animal is absolute. And this is so even if the owner had no prior knowledge of the animal's dangerous propensity to cause harm, and even if the owner has exercised the utmost care in preventing that harm. And remember here that an exception to this doctrine of absolute or strict liability is sometimes recognized where the wild animals are kept for government-sanctioned education and entertainment purposes. And in those cases, some jurisdictions apply the rules of ordinary negligence. Now we will take a look at two videos. The first video is about strict liability, and the second video is an explainer about intentional torts, negligence, and strict liability.
Strict liability in tort law. It is axiomatic that in most cases, some level of fault is necessary for tort liability to attach. In the case of negligence causes of action, for example, plaintiffs must prove that defendants breached their duties to succeed. An exception applies in cases of strict liability torts. Strict liability means liability without fault. Where applicable, the defendant is liable for harm that his actions caused, even though there may have been no misconduct at all by the defendant. Strict liability applies in three categories of cases. 1. Where the defendant kept wild animals that escaped their confinement and caused damage. 2. Where the defendant engaged in abnormally dangerous activities which caused damage. And 3. Certain product liability actions. Wild animals. Because wild animals can be vicious and unpredictable, keeping them is considered an inherently dangerous activity. By doing so, the keeper implicitly takes upon himself the risk of liability should the animals cause injuries. A wild animal is an animal that belongs to a category of animals that have not been domesticated and that are likely to cause personal injury if not restrained. Snakes, lions, and bears are classic examples of wild animals. If a person harbors a wild animal, even legally, then liability for injuries inflicted by the animal is absolute. This is so even if the owner had no prior knowledge of the animal's propensity to cause harm, and even if the owner had exercised the utmost care in preventing harm. An exception to the doctrine of absolute liability is sometimes recognized where wild animals are kept for government-sanctioned education and entertainment purposes. In those cases, some jurisdictions apply the rules of ordinary negligence. Where the animals in question are of a species that can be domesticated, ordinary negligence rules apply unless the owner knew or should have known that the animal has dangerous or vicious propensities. For example, if a domesticated dog engages in attacks on people, while the initial attacks might be subject to ordinary negligence analysis, later attacks will subject the owner to strict liability because the owner should have known that this particular animal is dangerous. This rule is sometimes known as the one free bite rule, on the idea that the first bite is not subject to strict liability. This is actually a bit of a misnomer, since even the first bite can subject the owner to liability if the owner was negligent, but it serves nevertheless to illustrate the rule. For example, in a 1969 case, the city of Alexandria, Louisiana, was held liable in negligence for injuries sustained by a 9-year-old boy while he attempted to feed a chimpanzee in a city-owned zoo. Though strict liability was not applied based on the education and entertainment exception that we just discussed, the record indicated that the animal had previously bitten off a finger of an employee and that the city was negligent, failing to provide wire mesh on the sides of the cage to restrain the public from approaching the cage. Therefore, the city could be liable either on the basis of negligence or on the basis of strict liability because they had reason to know this animal had dangerous propensities. Abnormally dangerous activities. Strict liability is typically applied in cases in which the defendant's activity was ultra-hazardous or abnormally dangerous. These terms are often used interchangeably or in the alternative, though the term ultra-hazardous was more common in older cases, while abnormally dangerous is the standard more frequently used today. An activity is abnormally dangerous if it, 1. necessarily involves a risk of serious harm to the person, land, or property of another, which cannot be eliminated by the exercise of the utmost care, and 2. is not a matter of common usage. While the activity need not be rare, abnormally dangerous activities by definition are not commonly carried out by a majority of people on a regular basis. That is why, for example, driving a car would never be considered an abnormally dangerous activity. Although driving a car may be dangerous, it's not abnormal for most people, and therefore cannot be considered abnormally dangerous. Though not all states apply strict liability to the same extent, there are some activities that tend to be universally labeled as abnormally dangerous. For example, dynamite blasting tends to be universally recognized as abnormally dangerous. The common view is that the extent and severity of any given blast is impossible to predict. Blasting involves a substantial risk of harm regardless of the degree of care exercised. Therefore, the person engaged in that activity assumes full responsibility for its consequences. Crop dusting, fumigating, other mass use of poisons, storing gasoline, burning fields, storing explosives, and digging canals are other examples of activities that are considered abnormally dangerous and thus subject to strict liability. It should be noted that the damages need not necessarily include only damages normally anticipated and associated with the dangerous dangerous activity. Damages also need not be limited to physical injury. They can include emotional pain and even loss of business profits. For example, a New York dentist successfully sued for damages caused by 6 months of blasting near his dental practice. The prolonged blasting caused him tension and anxiety. It also caused him to lose 2 business contacts. The dentist successfully sued for his physical and emotional anguish as well as the economic loss to his practice. Product liability. While product liability is the subject of other presentations, it should be noted in this context that manufacturers or sellers can be strictly liable for damages caused by products that they place into the stream of commerce. There are 2 basic categories to which these apply. 1. Manufacturing defects. Manufacturers are typically liable when a mistake in the manufacturing process causes an injury. Mistakes in the factory that cause screws to end up in soda cans, mistakes on the assembly line that cause cars to come off the line with defective brakes and rancid food that causes food poisoning are all examples of such defects. The manufacturer or retailer can be held liable even in the absence of any showing of fault or negligence. Breach of warranty. Where the manufacturer or seller of a product guarantees explicitly or implicitly that a product will behave in a certain manner, and it fails to do so, the manufacturer or seller will be held strictly liable for any resulting injuries, regardless of any fault or lack thereof. While negligence or intentional wrongful conduct is generally necessary for liability to attach, in these 3 categories of cases, no fault liability may apply. Like many legal exceptions, determining when strict liability applies often comes down to a case-by-case analysis, but the general principles laid out in this presentation should be sufficient as a starting point to determine when liability can apply, even absence a showing of fault on the part of the defendant.
Is that tort law varies from state to state. As explained in episode 1, tort law is a common law subject. Most of tort law has evolved through the holdings of individual court decisions. A published court opinion arising out of an individual dispute becomes a precedent, which is applied to future disputes that arise within the same jurisdiction. Tort law is almost exclusively a matter of state law, meaning that each state has developed its own set of precedents applicable within its jurisdiction. In some areas of torts, almost all jurisdictions follow the same basic approach. In other areas of tort law, there are jurisdiction splits, characterized by majority and minority approaches. When a rule or standard is described as the majority approach, that means that it is the approach followed by the majority of jurisdictions. Sometimes, particularly on matters of first impression, meaning that there is no precedent on point from the highest court in the relevant jurisdiction, courts will also look to holdings from courts in other jurisdictions and decide whether or not to follow the same approach. Early tort law in the United States borrowed from England, so you'll also see some early English cases cited by American courts. Sometimes, in addition to looking to precedents, courts will also look to something called a restatement. A restatement is something less than a code. It's not like a statute enacted by a legislature, and it's not like the federal rules of civil procedure or even the Uniform Commercial Code that's used in contracts. But a restatement is something more than a treatise. So it's not just another study aid or reference work. The restatements are published by the American Law Institute, an organization of legal academics and practitioners that was founded in 1923. A restatement is essentially an attempt to summarize case law. The ALI takes the whole body of common law, judge-made doctrines that have developed gradually over time, and it tries to synthesize them into a set of rules. Restatements are not binding authority in and of themselves, but they are highly persuasive. They are meant to reflect the consensus of the American legal community as to what the law is, and in some cases, what it should become. For torts, there are 2 restatements to keep track of. For most of tort law, the second restatement is the right place to look. The ALI has also promulgated a 3rd restatement, but this one is not comprehensive. It only addresses certain areas of tort law, like products liability. In torts, the restatements have not been as influential as they have been in some other areas of the law, like contracts. For that reason, it is not as crucial to know all of the ins and outs of the restatements for torts, but they can be helpful in figuring out doctrinal issues. We'll use them a fair bit in our discussions of intentional torts and strict liability, but less so for negligence. Now let's talk about the three main types of tort liability. Tort is not a single cause of action the way that breach of contract is. Rather, it is divided into several different types of claims or causes of action, all of which may be described as sounding in tort, meaning that they are based on tort law principles. Causes of action sounding in tort can be categorized as one of the three main types of tort liability: intentional torts, negligence, and strict liability. These categories are based on the differences in the defendant's action. Intentional torts involve civil liability for harms that are caused more or less deliberately by the defendant. For example, the defendant deliberately hits the plaintiff across the side of the head. Later in our episode on intent, we will flesh out what more or less deliberately means. Intentional torts is an umbrella term for several distinct causes of action, which include battery, assault, false imprisonment, trespass to land, trespass to chattels, conversion, and others. Each of these represents an intentional invasion of the plaintiff's legally protected interest. That might be an interest in being free from harmful, offensive contact with one's person, or in being free from apprehension of harmful or offensive contact, or an interest in freedom of movement, or a possessory interest in property. Negligence is the most common basis for tort suits. This is liability for harms that are not caused by the defendant deliberately, but for which the defendant is at fault because he or she, or it in the case of a business, was careless in some way. For example, the defendant, posing for a picture, backs up into the plaintiff, knocking him into oncoming traffic. Negligence is shorthand for an unreasonable but unintentional interference with the plaintiff's legally protected interests. So, roughly speaking, both intentional torts and negligence are based on wrongdoing or fault on the part of the defendant. Strict liability is something else altogether. It's made up of a few exceptional situations where the law assigns liability to the defendant even where the harm was caused by accident, unlike intentional torts, and even where the defendant was careful, unlike negligence. For example, the defendant's store owner sells a defectively manufactured blender, which malfunctions, injuring the plaintiff. The defendant's store owner may be liable, even though he wasn't responsible for causing the manufacturing defect, and even though he could not reasonably be expected to have discovered the defect before the sale, because the defective blender looked just like all the other blenders it received from the manufacturer. The idea behind strict liability is that the law assigns the cost of any consequences of the defendant's activity, no matter how unexpected or unavoidable, to the defendant. Now we also need to introduce a different label and explain that it's not really a distinct type of tort liability so much as a procedural mechanism for bringing a claim under one of the three types. In some jurisdictions, it's called wrongful death, or in others, it might be called a survival action. Whichever label is used, the idea is the same. A wrongful death or survival action is basically just what happens to a regular tort claim when the victim of the tort dies. Wrongful death and survival actions are made possible by statute. Under the old common law of England, there were 3 very restrictive rules concerning what happens when a party involved in a tort dies. Keep in mind that these are old rules that you don't need to know now. They simply provide background for understanding why wrongful death and survival actions were not possible under the old common law. 1. If the tortfeasor, the person who committed the tort, died before the victim recovered, the victim's right of action used to die with him. Now that's no longer true. You can sue the estate of the tortfeasor. 2. If the victim of the tort died from the tort itself or any other cause before he recovered in tort, the victim's right of action also died. Now that's no longer true. The estate of the victim or the victim's relatives can sue in his place using a wrongful death or survival action. 3. Finally, if the tortfeasor caused a victim's death, relatives and dependents of the victim who were deprived of financial support or suffered emotional loss did not have a cause of action of their own. Now that's no longer true. Not only can relatives sue in the place of the deceased victim using a wrongful death or survival action, claiming the damages that the victim would have been entitled to, but they can also sue in their own right for the harms that they have suffered as a result of the loss of their relative. For all intents and purposes, wrongful death and survival actions work exactly the same way that intentional torts, negligence, and strict liability claims do under the common law. So you'll sometimes see a case that's styled as wrongful death or survival, but the court basically treats it as if it's just another intentional tort, negligence, or strict liability case. For each cause of action, courts have established the basic elements that a plaintiff is required to demonstrate to establish liability. Taken together, these elements make up the prima facie case. For example, battery is an intentional tort cause of action. As we'll discuss in the next episode, it is made up of the following elements. 1. The plaintiff must show that the defendant intended to cause harmful or offensive contact. 2. The plaintiff must show that harmful or offensive contact actually occurred. 3. The plaintiff must show that the defendant's actions caused the plaintiff harm. And 4. The plaintiff must establish damages. Also, for each type of liability, courts have recognized affirmative defenses that the defendant can raise. For example, defenses to intentional torts include consent and self-defense. Defenses to negligence include assumption of risk and contributory negligence. The plaintiff has the burden of proof with respect to the prima facie case for whatever claims he, she, or it makes. What this means is that for the plaintiff to win, he has to convince a judge that he's going to be able to present sufficient evidence to convince a reasonable jury of facts that would support each of the prima facie elements. If he can't do that, the judge will throw the case out before it even gets to the jury. Then, assuming that the parties are unable to reach a settlement agreement, the plaintiff has to actually convince a real jury to a preponderance of the evidence standard, meaning more likely than not, of facts that would support each of the elements. Now, a quick note, we're saying jury here for simplicity's sake, but sometimes in a bench trial, there is no jury, and the judge also acts as fact finder. The defendant can respond at each stage in 2 different ways. A, by disputing the plaintiff's prima facie case, meaning presenting evidence to counter the plaintiff's argument that the defendant acted intentionally. And or B, by raising affirmative defenses, meaning presenting evidence to show that the defendant was acting in self-defense.
Okay, now we'll be taking a look at the types of damages under the torts law. You see, there are three types of damages that form the foundation of most civil lawsuits. These are compensatory, nominal, and punitive damages. Compensatory damages, nominal damages, and punitive damages. And in the legal world, you see, damages are the solution to the real life cost and consequences of one's wrongdoing to another. And a plaintiff must quantify his damages, usually with a dollar amount or other terms of payment. And most people, they consider these three types of damages when weighing their legal options, and these are compensatory damage, nominal damage, and punitive damage. And the potential to claim any or all of these damages, it will vary greatly depending on the plaintiff's cases, unique circumstances. So let's take a look at them one by one. First is compensatory damages. You see, in cases where one party broke a contractual agreement or breached their duty of care, the other party may pursue compensatory damages. And the breach of contract claims, for instance, can extend to all industries and arrangements between people and larger entities. And meanwhile, the negligence lawsuits that allege that a person had failed to exercise their duty not to harm another person or entity. And in pursuing compensatory damages, the litigation process, it involves determining if a contract or a duty had at all existed, and if so, which requirements the liable parties have breached. And both the parties or sides in a dispute can make a case for the extent of the breach and the consequential damages. You see, there are also other factors to consider, like the amount of hardship caused, the negligent or the willful behavior that contributed to the losses, and if the plaintiff can tie the losses to the dollar amount. And the plaintiffs pursuing these compensatory damages will typically benefit from a fully documented calculation for the claim amount of money lost. However, a plaintiff also can recover non-economic damages such as pain and suffering and loss of consortium, which might be challenging to quantify. And to recap, compensatory damages are comprised of two categories of damages. One is general and the next is special damages. So special damages are generally quantifiable, for example, an incurred medical expense. And general damages, on the other hand, are not easily quantifiable, and it includes pain and suffering, mental anguish, and future lost wages. And the injured party may also recover past and future medical expenses caused by the defendant, as well as past wages, future wages, and loss of earning capacity. And the main categories of general damages an injured person may recover are pain and suffering, mental distress, scarring or disfigurement, and loss of enjoyment of life. And also certain family members such as spouse and children, parents, siblings, or grandparents may also recover for the loss of consortium. So basically, loss of consortium, it means loss of love, loss of companionship and affection, or uncompensated household services, and spouses' impairment of sexual relation that they suffer as a result of injury to another family member. And a tort victim may also recover for damages to his property. And generally, the plaintiff may recover the fair market value of the property, the loss of use of the property, and in certain situations, even mental anguish. The plaintiff generally are awarded the interest from the date he files his lawsuit and may not recover, however, the attorney fees unless it is provided for in the statute or in contract. The next is nominal damages. You see, plaintiffs typically receive nominal damages when they establish that they have suffered harm due to another party's action, but a court deemed the injury very minimal or insignificant. And in cases where the plaintiff receives nominal damages, the dollar amount awarded is often no more than a few dollars. And the purpose of nominal damages, you see, is to show in the court records that the plaintiff had won the lawsuit while concluding that no real harm was done, that there was no real injury. A court may also award nominal damages when a plaintiff cannot prove the actual value of their losses resulting from the defendant's wrongful behavior. And in some cases, nominal damages may cover court fees that the plaintiff incurred while filing the lawsuit. And the purpose of nominal damages is, remember, is not to award either party in the suit a significant amount of compensation, but to show that the court has considered that the defendant's conduct was wrong. It was tortious. And next is punitive damages. You see, unlike compensatory damages, punitive damages are awarded to punish a defendant for willful, malicious, or fraudulent actions that have harmed another party and to make an example of them to discourage others from engaging in that behavior. For instance, a plaintiff may seek punitive damages for exceptionally negligent conduct that has caused, let's say, a significant property damage and severe injuries. But remember that not every tort lawsuit warrants punitive damages. While the juries might award substantial punitive damages, the judge can always decrease the amount of punitive damages based on the amount of compensatory damages that has been awarded. And the state laws also might limit the amount of punitive damages that a plaintiff may receive or recover. Now we'll take a look at a real world example. KV, are you there? KV?
Yes, I'm here.
Yeah, KV, can you read this case 7.3?
Okay.
Thank you.
Charles Clark was fatally injured in an automobile accident when he pulled into an intersection in front of an oncoming vehicle and collided with it. He was not wearing a seatbelt and was consequently ejected from his vehicle. His wife, Sue Chesler, claiming that its pickup truck was defectively and negligently designed. After a 3-day trial, the jury rendered an unanimous verdict in favor of Mrs. Clark on claims of strict liability, negligence, and the failure to warn. A jury found Chesler and Mr. Clark each 50% at fault, returning a verdict of $471,258.26 in compensatory damages and $3 million in punitive damages. The court entered a judgment against Chesler for $3 million $235,629.13, reflecting 50% of the compensatory damages plus the $3 million punitive damages award after a series of appeals, the last being an appeal of the trial court's motion to deny the defendant's motion to send the case back to the district court for a reduction of damages. The case finally landed at the circuit court and of appeals on the issue of whether the jury verdict was constitutionally excessive. Issue: should the plaintiff's $3 million punitive damage award be struck down as constitutionally excessive when the amount of the compensatory damage is 471,258.26. Reasoning. Application of the Gore guidepost to this case renders the punitive damage award excessive. According to Gore, 5 criteria are used to determine the reprehensibility of the defendant's conduct. First, the harm caused was physical as opposite to economic. Second, the tortuous conduct invents an indifference to all reckless disregard for the health or safety of others. Third, the target of the conduct had financial vulnerability. Fourth, the conduct involved repeated actions or was an isolated incident. And five, the harm was the result of intentional malice, trickery, or deceit, or mere accident. In this case, the physical harm suffered by Mr. Clark weighed strongly in favor of finding Chancellor's conduct reprehensible, but considering the 4 other factors leads to the conclusion that the factors as a whole show that Chancellor's conduct was not sufficiently reprehensible to warrant a 3 million punishment. The second guidepost is the disparity between the actual or potential harm inflicted or on the plaintiff and the punitive damage award, because the compensatory damage award here is relatively small. 1:1 ratio is inappropriate, but because of the lack of reprehensibility, a ratio higher than 2:1 would be unwarranted. The third guidepost is the difference between the punitive damage award and the civil or criminal penalties that could be imposed for comparable misconduct. Given State Farm's focus on civil penalties, a 3 million punitive damage award is excessive in light of comparable civil penalties. Decision and remedy. The damage award was excessive. Chancellor's motion was reversed and remanded with instructions to enter a punitive damage award in the amount of 471,258.26.
Thank you. So you see, this case, it gives us a little more insight and guidance about when the punitive damages may be considered excessive and when they will not be granted. Okay. Okay, now we will proceed on to the next subject of law, that is real, personal, and intellectual property. Real, personal, and intellectual property. You see, anything that can be legally owned may be called a property. And all property can be grouped into two main categories, real property and personal property. And personal property can be further classified as chattels and intangibles, chattels and intangibles. Let's talk about real property first. So real property are generally land and buildings, and real property, it describes lands and things that are attached to the land, which is why land is sometimes called real estate or realty. And even though wood, steel, and other building materials are not land themselves, but when they are built into structures that are attached to the land, they also become real property. And trees and other plants naturally growing on the land are also part of real property. But plants that requires human cultivation and labor, such as grain and vegetables, these are sometimes not treated as part of real property. So for a business, you see, real property includes immovable property that the business owns, such as land, buildings, crops, mineral rights. And for example, let's say that I am a farmer. I own a large piece of land, and on the land I have a house, a barn, a grain silo, and a stable. So each of these items, that is the house, the barn, the grain silo, and the stable, is a piece of real property because these items are attached to the land. What about personal property? See, personal property is all property that is not a real property, and that's a big category. It can be further divided into two subgroups, chattels and intangibles. And when we think about chattels, you see the term chattel, sometimes it refers to all kinds of personal property, but it often refers only to the tangible personal property, such as even things like car or motorbike, or things like the car or motorbike, or any kind of things that are, or any kind of property that's movable, as opposed to intangible or immovable property. And a chattel, you see, such as a furnace, can also be affixed to land and it can become part of the real property, and such chattels are then called fixtures. However, fixtures may retain their quality as separate personal property for certain purposes. For example, at the end of a lease term, the tenant generally has the right to remove the fixtures, right, that she has installed, even though she does not have any more right to the real property when the lease ends. And for business, tangible personal property, it includes items the business owns, such as an office furniture or a business equipment or a business vehicles or business goods. And what about intangible personal property? You see, intangibles are all kinds of personal property that are not tangible, that cannot be seen, felt, or touched. So you can say that this kind of property does not involve a thing at all. It only involves a legal right. And the mere existence of such a category of property, you see, is a reminder that in the law, in the eyes of law, property most accurately refers to legal rights and not to things themselves. And the business can own all sorts of intangible things, including the following, that is bank account, franchises and licenses, or insurance policies, or intellectual property such as patents, copyrights, trademarks, etc. And you see stocks, bonds, promissory notes, and similar documents. You see, they themselves are not valuable, but mainly they represent intangible rights. And currency also sometimes treated as an intangible property. And in this regard, we also have to know that there's certain things, certain property that cannot be owned. You see, some things cannot be owned at all, and therefore they cannot be private property. And some of these things are such as light, air, and the high seas. These cannot be owned because they naturally seem communal. And other things such as rivers and coastal waters, they also cannot be owned because they belong to the public. And some things cannot also be owned because they are simply illegal, like drugs or heroin or marijuana. And then let's discuss about the extent of ownership of real property. You see, ownership of real property is unique in that sense that an owner will acquire many different types of rights associated with the land. And these extended land rights are often referred to as a bundle of rights. And the bundle consists of a variety of privileges, including rights to the surface of your land and to the spaces above and below the surface of your land. So let's talk about surface rights first. Let's start with the area that we can easily see. You see, I know that I have surface rights to my land. Surface rights are the rights to use, to improve and sell the surface of the land. This means I have the right to occupy the land, build on the land, and otherwise use the surface area of my land. And surface rights are the right we commonly think about when we think about land ownership rights. And because I own the surface rights, I can build a house on my land. I can build a barn or a shed on my land. I can build myself a private road or a driveway. I can also plant crops or trees on my land. And I can do many other types of activities. You see, I'm limited only by my local zoning codes. And note that the surface rights can be bought, they can be leased, or they can also be sold alone. And while the land usually comes with a bundle of rights that includes surface rights, those rights can also be separate from the bundle. How about air rights? You see, when I buy a piece of land, I also acquire air rights. Air rights are the rights to control, occupy, or use the vertical space above my land. Air rights are usually more limited than the surface rights, and these rights are not usually absolute. This means that others can also use the space above my land if it is reasonable and necessary for others to do so. For example, I cannot limit the space above my land to an aircraft. If I'm in an aircraft or an airport's flight pattern, I cannot direct that the aircraft fly around my land rather than over my land. I also cannot prohibit a utility from extending wires or poles across my land when it is necessary to reach my neighbors. And like surface rights, air rights can be bought, they can be leased or sold alone by itself separately. And remember that the land usually comes with a bundle of rights that includes air rights, but again, those rights can also be separate from the bundle. And the sale of only a property's air rights is somewhat unusual, but it's becoming actually more commonplace in densely populated areas. How? For instance, the owners of two commercial buildings might want to build an overhead walkway or a bridgeway joining their buildings across a parking lot that I own, and they will pay me handsomely for the right to build in my airspace. How about other rights? You see, in addition to having airspace rights, the owner of a real property will also have water rights and the legal ability to use water flowing across or underneath the property. However, these rights are somewhat restricted. One cannot deprive the landowners downstream from the use of the water by diverting the water elsewhere. And finally, ownership of real property also extends to mineral rights. And these rights involve the land below the surface or the subsurface. The landowner has the legal ability, you see, to dig or mine the minerals from the earth, and he may sell or give these rights to another person. And ownership of the subsurface rights include the right to enter onto the property to remove the underground material. And from this diagram also you can see that these are the different kind of rights the owner of a real property may enjoy: the airspace rights, the water rights, and the mineral rights, or the subsurface rights. Now let's take a look at possessory interest or estates in land. Possessory interest or estates in land. You see, interest or estates in real property can be possessory or non-possessory. A possessory interest is the intent and the right of a party to occupy or exercise control over a particular plot or area of land. And we will discuss about this possessory interest or estates first. You see, they are fee simple absolute. What is fee simple absolute? You see, a fee simple absolute is an ownership interest that includes all rights in the land. And just as the word suggests, This type of estate represents absolute ownership of the land. A fee simple absolute owner may do whatever he or she chooses with the land. The owner can use the land, destroy the land, give the land to someone else, and take items from the land. The landowner is limited only by the zoning and the building codes or other governmental restrictions only. The landowner can deed or will the entire fee simple estate to another person. This means that should the landowner die without will, the fee simple absolute ownership will automatically pass to the owner's heirs. How about conditional estate? See, sometimes a fee simple interest is not absolute. There are times when a fee simple interest is granted, but the interest comes with certain conditions. And these are known as conditional estates. Let's take a look at two examples. You see, a fee simple determinable is an ownership interest that automatically ends when a specified event occurs. For example, let's say that I grant my farm to a local agricultural college, and my deed says that I grant my land to the university as long as it is used for educational purposes. This means that if the university stops using the land for educational purposes, the grant automatically ceases and I own the land again. Or if I am deceased, my heirs will own the land. This is similar to a fee simple subject to a condition subsequent. In this type of ownership interest, you see, a landowner may reclaim the land if a specified event occurs. And notice that unlike the fee simple determinable, the ownership interest doesn't automatically terminate. For example, let's say that I own a land and I grant my land to the university, but specify that if corn ceases to be grown on the land, I can reclaim the land. So if the university decides not to grow the corn, I can reclaim the land, or my heirs may reclaim the land if I am deceased. And next is life estate. You see, a life estate is a land interest that expires upon the death of a specified person. For example, let's say that I own a land and I grant my land as a life estate to my sister Susie. This means that Susie can occupy, possess, and enjoy the property when only during her lifetime, just as if it were a fee simple. However, Susie's ownership interest in the land will automatically stop upon her death. And rather than passing down to her heirs, the land will pass back to me. Or if I am deceased, the land will pass to my heirs. Susie cannot will the property in this case to another person. You see, life estates are not common, but this type of interest can be helpful for estate planning purposes. Let's say that Joseph is married to Ruby and both have children from previous spouses. And Joseph wants Ruby to be able to live on and enjoy his land after his death. So he grants her a life estate. However, after Ruby's death, Joseph wants his land to go to his children or heirs rather than Ruby's children or heirs. The life estate in this case assures that the land will revert to Joseph or to his heirs upon Ruby's death. And if Joseph granted Ruby a fee simple, then the land would have instead gone to Ruby's heirs upon Ruby's death. How about future interest? You see, a future interest is in direct contrast with a present right to property, also referred to as a possessory estate. A future interest may be conditioned upon the occurrence of a certain condition or event, or it can also be unconditional. And future interests, you see, are created at the formation of a divisible estate. What is a divisible estate? A divisible estate is created when a grantor transfers land conditionally. And the future interest will either take effect following the natural termination of the prior estate, or it will cut short the prior estate. Therefore, you can say that the future interest is a non-possessory interest, that is an interest that does not include the current right of possession, that can become possessory in the future. A person with a future interest in land does not have any present rights or privileges as far as the land is concerned. And what he or she does have is an interest that will give him or her the rights and privileges in the land at some point of time in the future. For example, let's say that Joseph owns a life estate in Vine Village apartment. And on his death, the property will pass to Sarah, with fee simple absolute rights. And Sarah in this case holds a future interest in Vine Village apartments, and if Joseph allows the buildings to deteriorate from neglect, Sarah may sue Joseph to enjoin him from engaging in west of the property. And finally, we come to leasehold estate. A leasehold or a lease, you see, is an interest in real property that grants the possession for a particular duration. The lease can last for 1 year, can last for many years, can be week to week, or can be even month to month. The duration does not matter so long as it is specified in some way. A leasehold doesn't grant actual title to the land. Therefore, the lease owner cannot will the property to someone else. And rather than a deed or a title, the lease owner will have a lease agreement that dictates the rights and obligations of both the lease owner and the property owner. And the lease will terminate and the property owner will regain all the rights if one or both parties violate a term of the lease agreement. Now we will take a look at the non-possessory interest or estates in real property. You see, non-possessory land interests are those that give their holders certain definite and clear-cut rights that always fall short of possession of the land. And these non-possessory interests might be labeled as privileges, liberties, or advantages. And non-possessory interests give their holders some right of entry or use of the land of another. And you see, non-possessory land interests are generally of three types. What are these? These are easement, profit, and license. What is an easement? An easement, you see, is a liberty. It's a privilege or an advantage in another's property. It is a non-possessory interest, but may be valid for perpetuity. Easement is a non-possessory right to use another person's land in some limited way that does not constitute full ownership. The person or the legal entity that benefits from the easement has a non-possessory interest, that is the right to use the property and not to possess the property itself in the other person's land. And the owner of the property is burdened by the easement. Common easements include rights of way, drainage, ditches, public utility lines, and easements by condemnation, that is eminent domain. Thus, you see, easement is a non-possessory limited right to use another's property in a manner established by express or implied agreement. For example, as I said, the right to use a road to get to your property, or the right of a utility company to bury a cable on your property at a certain location. And sometimes these easements can also be purchased and sold. Next is profit. You see, profit is the right to enter upon and remove things, example, trees or oil or mineral or topsoil from the property of another, and is usually for a fee. And this profit gives the holder the right to take natural resources such as petroleum, minerals, timber, and wild game from the land of another. And indeed, because of the necessity of allowing access to the land so that the resources may be gathered, you see, every profit, it contains an implied or an underlying easement for the owner of the profit to enter the other party's land for the purpose of collecting the resources permitted by the profit itself. And next is license. You see, license is a revocable. It's a revocable right or a privilege to come onto the land of another. And generally, a license permits the licensee to use the licensor's land for a specific purpose, but it confers only a personal privilege that cannot be assigned and is terminable at will. A license does not create an interest in the land and cannot be conveyed to the heirs or other third parties. And licenses are generally revocable or for a stated period of time. For example, when the US Open golf tournament was played at Baltusrol Golf Club a few years back, you see, some homeowners near the course had allowed the attendees of the golf tournament to park on their properties, and so that they have quicker access to the golf course. And thus, that way, a license was created. A license is simply a permit or a privilege to do what otherwise would have been considered as an unlawful trespass. Now let's talk about transfer of real property. You see, real property can be transferred in many ways, both voluntarily and involuntarily. There are three ways you can voluntarily transfer or grant an interest in real property while you are living, that is by sale, by gift, or by dedication. In a sale, you transfer your property in exchange for something else of value called a consideration. And to make such a transfer effective, you must follow certain legal procedures. And these procedures are execution, delivery, acceptance, and recording, the last of which is required to protect the recipient of the property. And such a transfer is presumed to be the conveyance of a fee simple absolute unless the contrary is stated. And when you transfer your property without getting anything of value in return, it is transferred as a gift. Unless it is as a transfer of nominal ownership only, that is a change in name only. And when you transfer your real property or a portion of it to the government, it is called the dedication. Also note that there are several ways your real property can be involuntarily transferred away from you, that is without your consent and without your agreement. And this includes condemnation or eminent domain, foreclosure, adverse possession, or partition. You see, federal or state and local governments, they all have the power of eminent domain, which means that your property can be taken in exchange for just compensation to be used for the public benefit. The legal process used here is called a lawsuit for condemnation, which means that you must receive notice and an opportunity to challenge both the taking and the amount of compensation given to you for your real property. And if you either do not want to sell or feel that the price offered by the government is too low, the government will initiate a condemnation proceeding and the court will determine whether the government body bringing the action has a valid claim that the taking is for a legitimate public purpose. And if the court determines that in fact that the taking of the property will benefit the public interest, the court will then determine the fair market value of the property. And this price will then be paid to you and the property will be transferred to the government. And also note that your real property can also be taken involuntarily from you in order to pay off your debts that you had agreed to pay. And this process is known as foreclosure. And your real property is sold off to pay off your debts. The types of debt that can be paid off with foreclosure include mortgage liens, judgment liens, mechanic liens, and also tax liens. And property to be foreclosed upon must be subject to a mortgage or a lien of some kind, such as a judgment or tax lien. Another involuntary method of transferring your real property is called adverse possession. And this happens when you do not occupy or visit your land and have not clearly marked its boundaries. Another person or persons may claim ownership of the land in such a case and may use it exclusively and openly for a period of 10 years. And after that time, this other person who has adversely possessed your land can bring a quiet title action and gain the title to your real property. And this is typically applied to a partial interest in property, such as a right of way. And what about partition? A partition action is also another way your real property may be transferred involuntarily. Partition happens when you own property together with another person or persons and you cannot agree on what to do with the property or how to use it. And the other owners can then file a partition action to ask the court to either divide the property physically or forcibly sell it to divide the proceeds from the sale. And there are also three ways your real property can also transfer after your death. What are these three ways? These are by will or by descent, that is an estate without a will, or by escheat. It's a very rare situation where the property owners has no will and no heirs. Now let's discuss about personal property. We have already discussed earlier about what is personal property and the two types of personal property, that is tangible and intangible. See, tangible property is property that can be identified by the senses. You can see it, you can feel it, you can touch it. Tangible property includes items such as furniture, car, and other goods. On the other hand, you see intangible property, which includes such items such as bank accounts, stocks, and insurance policies, is that property that does not derive its value from the physical attributes. And some intangible property might have a paper embodiment, such as a stock, bond, or certificate, but other intangible property does not. For example, goodwill, intellectual property, or reputation. And due to these characteristics, intangible property may be difficult to value, but nonetheless, it is still a form of property. And how does personal property can be transferred? You see, so far as transfer is concerned, as in the case of real property, transfer of personal property can be voluntary or involuntary. Ownership of property passes or gets transferred when the title of the property passes from one person to another. And in most cases, when a personal property is transferred by purchase, the acquiring party has to give some kind of consideration to the seller in exchange for the title to the property. And generally, a transfer of ownership usually requires, you see, no formalities, but in some cases, such as the sale of a vehicle or motorboats or aircraft, the transfer is required to be registered with the appropriate government agency. It means to transfer such a property, the seller must sign the certificate of transfer and then submit it to the appropriate government agency, and that agency will then reissue the title in the name of the new owner of that personal property. And personal property may also be voluntarily transferred as a gift or through a will. And as for involuntary transfer of ownership, you see, such transfers can take place when the personal property has been misplaced or lost or abandoned. In such cases, the person who finds the property becomes a new owner. And in some states, however, the law requires that before becoming the owner of a lost or a misplaced property, a finder must place an advertisement in the paper that will give the true owner notice that the property has been found, and or must leave the property with the police for a statutorily established reasonable period of time. Now let's talk about intellectual property. What is intellectual property? You see, intellectual property, also called IP for short, it refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols and names and images that are used in trade and commerce. In general terms, intellectual property is any product of the human intellect that the law protects from unauthorized use by others. See, the ownership of intellectual property inherently creates a limited monopoly in the protected property. That is, the intellectual property rights usually give the creator an exclusive right over the use of his or her creation for a certain and a specific period of time. And intellectual property is traditionally comprised of four categories. What are these? These are patents, copyright, trademark, and trade secrets. You see, the US Patent and Trademark Office, that is the USPTO, is responsible for issuing and monitoring federally registered trademarks and patents. And although the patents are exclusively governed by federal law, trademarks may also be regulated by the state law. And copyrights are exclusively regulated by federal law and must be registered with the US Copyright Office for them to be enforceable. And trade secrets are primarily regulated at the state level and are traditionally subject to the laws of unfair competition. So now let's take a look at the types of intellectual property. Let's start with trademark. You see, a trademark is a symbol, a phrase, or an insignia that is recognizable and represents a product that legally separates it from other products. A trademark is exclusively assigned to a company, meaning the company owns the trademark so that no other companies or entities or people may use or copy it. A trademark is often associated with a company's brand also. For example, the logo and the brand name of Coca-Cola is owned by the Coca-Cola company. Thus, a trademark is a word, a phrase, a symbol, or a design or a combination thereof that identifies and distinguishes the source of the goods of one party from those of others. For instance, your company name, a logo, or your company's tagline can be trademarked. The trademark also serves as a brand identifier for your business or for your product. Images, slogans, and colors, these can all be trademarked. For instance, Tiffany blue is a trademarked color that is used by Tiffany and company in promotional materials as well as boxes, bags, and more. You see, words, phrases, and pictures are generally the most common intellectual properties to be trademarked. However, other distinguishing features can also be registered for your company. For example, Coca-Cola bottles have a trademark shape. Dell and Ford have trademarked their family names and even the smells. And these are known as non-conventional trademarks, but are used in every industry to protect the intellectual property. And it is important to protect these business assets, as trademarks give the business owners the tools or the means to prevent competitors from taking advantage of the goodwill that one's brand has accumulated over the years. What about copyright and the use of and the fair use doctrine? You see, copyright provides authors and creators of original material the exclusive right to use, copy, or duplicate their material. The authors of books have their works copyrighted, as do musical artists. A copyright also states that the original creators can grant anyone authorization through a licensing agreement to use the work. Thus, copyrights protect the writing, pictures, photos, music, art, and other forms of intellectual works. And what this means for you is that if you wrote something down or created a piece of work that you don't want people to reuse without your permission, or you have taken a photo that you do not want others to reuse without your permission, you have the right to copyright that work. And now if people want to use, reuse, or repurpose your work, they must first contact you to use it, attribute you as the owner, and use it for purposes you deem appropriate. And there is an exception to this rule, and that is fair use doctrine. It means that if someone wants to use a portion of your work for educational purpose, or for parody, or for commenting, or for news purpose, they can. Next is patents. You see, a patent is a property right for an investor or an inventor that's typically granted by a government agency such as the US Patent and Trademark Office, that is the USPTO. And this patent allows the inventor exclusive rights to the invention, which could be a design, a process, an improvement, or a physical invention such as a machine. And technology and software companies actually often have patents for their designs. For example, the patent for the personal computer was filed in 1980 by Steve Jobs and 3 other colleagues at Apple Inc. Therefore, we can say that a patent for an invention is the grant of a property right to the inventor. And generally, this patent lasts for 20 years from when the inventor attempts to patent their invention by filing with the US government. The list of things that can be patented is fairly lengthy and open to interpretation, but it covers anyone who invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof. That person may obtain a patent. For a business owner or an inventor, you see, this means that if you have found a new way to make something or discovered a new product that you would like to take to the market, you would want to first patent the idea so that no one can take that idea or steal that idea and claim it as their own. For instance, if you have a revolutionary water bottle that you feel would benefit the masses, you should protect this intellectual property by filing with this patent office that the idea is unique and your own. And if the government agrees that the idea is your own, unique, and is useful, then you will be awarded a patent to protect your right to that concept or idea. This then gives you the ability to produce the concept, sell it, or bring the concept to the investors without worrying about them stealing your ideas. However, a small word of caution: if you share your patented ideas, there's a risk that others will reverse engineer your concept. You see, reverse engineering is when the competitors, they will take apart an object or idea to understand how it functions with a goal of enhancing or modifying the object in order to replicate it. And making enough variations to the original concept can result in a unique idea that your competitors can then patent as their own idea, and companies can avoid compensating you for your patent ideas and claim these new versions of your ideas their own. And this frequently happens in the technology industry between companies like Samsung and Apple, and we will be going through a video of this kind of technological battle between Samsung and Apple over patent ideas. Then let's talk about trade secrets. You see, a trade secret is a company's process or practice that is not public information which provides an economic benefit or an advantage to the company or the holder of the trade secret. And trade secrets must be actively protected by the company and are typically the result of the company's research and development. And examples of trade secrets could be a design, a pattern, a recipe, a formula, or proprietary process even. You see, trade secrets are used to create a business model that differentiates the company's offerings to its customers by providing a competitive advantage. Therefore, any piece of confidential corporate information which gives any business a competitive advantage can be considered as a trade secret. For instance, Coca-Cola's secret formula could be considered a trade secret. Now, if I created a soda company and produced identical soda to Coca-Cola, this would be an infringement of Coca-Cola's trade secret. And this is a general example, but trade secrets can even be defined as distribution methods. For example, the distribution method adopted by Walmart, or the sales method, or the consumer information, or the ad campaigns and strategies, and list of vendors, or the list of clients, as well as the production processes. You see, generally trade secrets are leaked through corporate or industrial espionage or breach of trust, or something as simple as leaving your prototype iPhone at the bar. And remember that a trade secret must be designated as such before it is leaked. One cannot simply say, I have a secret. You must use non-disclosure agreements and designate information as trade secrets in contracts when dealing with partner companies or with your employees. So the next question that arises is, how do we protect intellectual property of our business? You see, businesses are often unaware that their business assets include intellectual property rights. And your intellectual property, you see, is a valuable, intangible asset that should be protected to enhance your competitive advantage in the marketplace. And intellectual property, like I have said before, it includes copyrights which cover works of authorship such as books, logos, software. It also includes patents which protects inventions, as well as other types of intellectual property. It includes trademarks, designs, and trade secrets. And the first thing you need to do to safeguard your intellectual property is to file for protection in the United States if you are living in the United States. And your state's bar association can recommend experienced lawyers who can help you with that. Then you must be the first inventor to file for protection in the countries in which you currently do business or are certain to do business in the future. You should also consider filing for protection in countries that are well known for counterfeit markets. So if you do business in nations that have free trade agreements with the United States, intellectual property protections are built into those agreements, but you will still need to file in each country to get those protections. And conversely, if you do business in any country in the European Union, you only need to file for protection with the European Union and not with every individual nation. And remember that if you have a registered intellectual property right in the United States, these protections are territorial and do not extend to foreign countries. And additionally, most countries are a first to file country for trademark registration and a first inventor to file for patent registration. And therefore, they grant registration to the first filer regardless of first use in the market. And if you have a patent or a trademark to file and register, you will need to do it with the United States Patent and Trademark Office, that is the USPTO, which is the federal agency that's responsible for granting the US patents and registering the trademarks. And if you need to register a copyright, the US Copyright Office, which administers the national copyright system and provides advice on copyright law to the Congress, to the federal agencies, the courts, and the public, it will be able to help you out. As for the trade secrets, you see, you need to take 4 steps to protect your trade secret. These are: number 1, identify the trade secrets in your company. Number 2, mark them as confidential, and you may have several levels or layers of confidentiality. Number 3, make a list of key positions, that is not individual people, and the type of secrets they may have knowledge of. And number 4, you must control the access to these secrets. And if you think that your trade secret has been stolen, you should approach the US court that can help you protect a trade secret by ordering that the misappropriation be stopped, or that the secret be protected from public exposure, and in extraordinary circumstances by asking the court to order the seizure of the misappropriated trade secret. Now, at the conclusion of a trade secret case, the courts can also award damages, court costs, reasonable attorney fees, and the permanent injunction if necessary and warranted. And if you want to learn more about trade secrets, you can read all about the Economic Espionage Act of 1996 that criminalizes the trade secret theft under 2 sets of circumstances. The economic espionage, you see, refers to the theft of a trade secret intending or knowing that the offense will benefit any foreign government, foreign instrumentality, or a foreign agent. The second offense, the theft of trade secrets, it addresses theft that is related to a product or service used in or intended for use in interstate or foreign commerce to the economic benefit of anyone other than the owner thereof, and intending or knowing that the offense will injure any owner of the trade secret. And you see, these are crimes, and these are prosecuted by the Department of Justice, and they're punishable by imprisonment and or fine. And the other legislation is the Defend Trade Secrets Act of 2016, that is the DTSA, which had amended the Economic Espionage Act to establish a private civil cause of action for the misappropriation of a trade secret. And this cause of action provides trade secret owners with a uniform and a reliable and a predictable way to protect their valuable trade secrets anywhere in the country. And this Defend Trade Secrets Act, it does not preempt existing state trade secret law, thus giving the trade secret owners the option of state or federal venues. And also, do not forget to visit the website of WIPO, that is the World Intellectual Property Organization. It's www.wipo.int. It is the world's #1 source for global intellectual property, that is patents, industrial designs, copyright, trademarks, etc. For the information about all these, the resources and the services. And the 2 main objectives of WIPO are: number 1, to promote the protection of intellectual property worldwide. And the second objective is to ensure administrative cooperation among the intellectual property unions established by the treaties that WIPO administers. Now let's take a look at these 3 videos. The first is a video on the Apple versus Samsung, which is the biggest rivalry in the tech industry.
Apple for a while or know the company's history, you'll probably remember them having quite a few rivals over the past 35 years. In the 80s, it was IBM. In the 90s, it was Microsoft. And in the 2000s, it eventually became Google. But the rivalry between Apple and Samsung is more recent and more unique, since Samsung not only competes with Apple in the notebook, tablet, and smartphone markets, but also supplies Apple with key components for their devices, like the iPhone's OLED display and flash memory chip. So let's explore how the 2 companies' relationship soured and how they feel about each other today. This is Greg with Apple Explained, and if you want to help decide which video topic I cover, make sure you're subscribed, and these voting polls will show up in your mobile activity feed. And don't forget to check out our new iGenius plush doll at appleexplained.com. Now, many of us today have become familiar with Samsung through the consumer electronics they sell, but those business endeavors are actually a fairly recent development considering the company's long history. In the 80s, Samsung's electronics division was focused primarily on the semiconductor business, and their then CEO, Lee Byung-chul, spoke with Steve Jobs on several occasions for advice or negotiations. In fact, the two met in person in 1983 at Samsung's offices in Seoul. Around that time, the company decided to make a sizable investment in a new chip plant in China. It's unknown if Jobs encouraged Samsung to expand their semiconductor business, but the two CEOs clearly had a friendly relationship. Apple went on to become Samsung's biggest client, ordering billions of dollars worth of electronic parts. But the friendly and cooperative relationship between Apple and Samsung didn't last forever. Before the original iPhone was announced, then Samsung CEO Lee Jae-yong visited Apple's headquarters to meet Jobs. It was then when Jobs revealed the device to Jae-yong and disassembled it, explaining how the iPhone's technology worked. And as you might expect, Samsung took the idea and ran, releasing their own touchscreen smartphone called the Galaxy just 2 years later, which ran on Google's Android operating system. As a result, Jobs asserted that Android was a stolen product and eventually called Samsung a copycat. It was at this moment when Samsung went from being Apple's ally to Apple's enemy, and the lengthy legal battle that began between the two companies in 2011 was proof that Apple was prepared to protect its intellectual property at any cost. The 7-year lawsuit war started with Apple striking first in 2011, but it wasn't something that came out of the blue. In fact, Apple approached Samsung in 2010 and told them up front that their smartphones and tablets were infringing on Apple's patents. And because the two companies had a long history of cooperation, Apple was willing to work out a deal. They proposed a licensing agreement where Samsung would pay Apple up to $30 for every phone sold and up to $40 for every tablet. But the company declined, since they didn't believe their products had infringed on any of Apple's patents. So the following year, Apple issued the lawsuit, claiming, instead of pursuing independent product development, Samsung has chosen to slavishly copy Apple's innovative technology, distinct user interfaces, and elegant and distinctive product and packaging design in violation of Apple's valuable property rights. So was this true? Did Samsung really rip off the iPhone and steal features that Apple had patented? Well, let's see how Samsung smartphones looked before the iPhone and after the iPhone. So I think it's pretty obvious that Samsung borrowed heavily from innovations the iPhone pioneered. But what exactly were the offenses? After all, in a lawsuit, a company has to point out specific violations of their patents in order to successfully make their case. Well, Apple made a total of 16 claims against Samsung, but I want to focus on 3 in particular: trade dress infringement, trademark infringement, and infringement of design patents. Let's start with the first one, trade dress infringement. Now, what does that even mean? Well, a trade dress is the visual appearance of a product or its packaging that represents its source. In other words, it prevents companies from imitating other products in the marketplace as to prevent confusion among consumers, who may believe they're buying a product from a certain brand when in reality it's just a knockoff. And that's why we see so many knockoff Apple products sold in China, but rarely in America, because our trade dress laws protect companies from imitators. In fact, the very first iMac was imitated by an American company called eMachines with a product called the E1. It was clearly a knockoff of the wildly popular iMac, but it didn't do too well since Apple successfully sued the company through a trade dress claim. Now, clearly Apple felt Samsung was doing the same thing by ripping off the iPhone and iPad's trade dress for their various devices. And as you can see from this picture, there are quite a few striking similarities that aren't likely due to sheer coincidence. Next is trademark infringement. And this is where things get a little obvious, because while Samsung may have been able to argue that the similarity in hardware design was incidental, the similarities in software elements like the icons became much more difficult to defend. There are literally hundreds of ways to design any given icon, and in many cases, Samsung just so happened to choose the same visuals as Apple. And third was infringement of design patents. These included the home screen icon layout, the form factor of the iPhone's chassis, and the screen and button designs. So if we add all of that up, we have claims ranging from branding to software design to hardware design. Essentially, every major component of these select Samsung devices Apple claimed were copied from their iPhone. And what did the court think of all this? Well, they ruled in Apple's favor. They ordered Samsung to compensate Apple $1 billion for their infringements and to never do it again in the future. But this wasn't the end of the story. In fact, the two companies were just getting warmed up. Samsung ended up appealing the verdict and countersued, claiming some of Apple's products were infringing on their patents. This legal back and forth continued for years, with both sides enjoying some wins and suffering some losses. Apple managed to ban Samsung's Galaxy Tab from Germany, which forced the company to redesign the device, but Apple was also found guilty of infringing on Samsung's cellular data patent with the AT&T iPhone 4, 3GS, and 3G, as well as models of the original iPad and iPad with 3G data radios, which meant Apple would be banned from selling AT&T models of some iPhones and iPads in the US. But the White House had a chance to veto the decision, which is exactly what President Obama did. Now, the 7-year-long lawsuit war came to an end in June 2008 when Apple and Samsung agreed on an undisclosed settlement. Although it's unknown what that settlement was, it's worth considering how much damage the entire ordeal had on both companies and how little each were compensated in return. But clearly, Apple saw the legal battle as a victory when they released this statement. We believe deeply in the value of design, and our teams work tirelessly to create innovative products that delight our customers. This case has always been about more than money. Apple ignited the smartphone revolution with the iPhone, and it is a fact that Apple blatantly copied our design. It is important that we continue to protect the hard work and innovation of so many people at Apple. We're grateful for the jury for their service, and pleased they agree that Samsung should pay for copying our products. Samsung declined to comment. Now, you'd probably imagine that after all those lawsuits, Apple and Samsung would want nothing to do with each other. But it turned out to be quite the opposite. Because Samsung still provides Apple with crucial components for their most popular products, the iPhone X's beautiful OLED display was brought to you by Samsung, as well as them having quite a few rivals over the past 35 years. In the 80s, it was IBM. In the 90s, it was Microsoft. And in the 2000s, it eventually became Google. But the rivalry between Apple and Samsung is more recent and more unique, since Samsung not only competes with Apple in the notebook, tablet, and smartphone markets, but also supplies Apple with key components for their devices, like the iPhone's OLED display and flash memory chip. So let's explore how the two companies' relationship soured and how they feel about each other today. This is Greg with Apple Explained, and if you want to help decide which video topic I cover, make sure you're subscribed, and these voting polls will show up in your mobile activity feed. And don't forget to check out our new iGenius plush doll at appleexplained.com. Now, many of us today have become familiar with Samsung through the consumer electronics they sell, but those business endeavors are actually a fairly recent development considering the company's long history. In the 80s, Samsung's electronics division was focused primarily on the semiconductor business, and their then CEO, Lee Byung-chul, spoke with Steve Jobs on several occasions for advice or negotiations. In fact, the two met in person in 1983 at Samsung's offices in Seoul. Around that time, the company decided to make a sizable investment in a new chip plant in China. It's unknown if Jobs encouraged Samsung to expand their semiconductor business, but the two CEOs clearly had a friendly relationship. Apple went on to become Samsung's biggest client, ordering billions of dollars worth of electronic parts. But the friendly and cooperative relationship between Apple and Samsung didn't last forever. Before the original iPhone was announced, then Samsung CEO Lee Jae-yong visited Apple's headquarters to meet Jobs. It was then when Jobs revealed the device to Jae-yong and disassembled it, explaining how the iPhone's technology worked. And as you might expect, Samsung took the idea and ran, releasing their own touchscreen smartphone called the Galaxy just 2 years later, which ran on Google's Android operating system. As a result, Jobs asserted that Android was a stolen product and eventually called Samsung a copycat. It was at this moment when Samsung went from being Apple's ally to Apple's enemy, and the lengthy legal battle that began between the two companies in 2011 was proof that Apple was prepared to protect its intellectual property at any cost. The 7-year lawsuit war started with Apple striking first in 2011, but it wasn't something that came out of the blue. In fact, Apple approached Samsung in 2010 and told them up front that their smartphones and tablets were infringing on Apple's patents. And because the two companies had a long history of cooperation, Apple was willing to work out a deal. They proposed a licensing agreement where Samsung would pay Apple up to $30 for every phone sold and up to $40 for every tablet. But the company declined, since they didn't believe their products had infringed on any of Apple's patents. So the following year, Apple issued the lawsuit, claiming instead of pursuing independent product development, Samsung has chosen to slavishly copy Apple's innovative technology, distinct user interfaces, and elegant and distinctive product and packaging design in violation of Apple's valuable property rights. So was this true? Did Samsung really rip off the iPhone and steal features that Apple had patented? Well, let's see how Samsung smartphones looked before the iPhone and after the iPhone. So I think it's pretty obvious that Samsung borrowed heavily from innovations the iPhone pioneered. But what exactly were the offenses? After all, in a lawsuit, a company has to point out specific violations of their patents in order to successfully make their case. Well, Apple made a total of 16 claims against Samsung, but I want to focus on 3 in particular: trade dress infringement, trademark infringement, and infringement of design patents. Let's start with the first one, trade dress infringement. Now, what does that even mean? Well, a trade dress is the visual appearance of a product or its packaging that represents its source. In other words, it prevents companies from imitating other products in the marketplace as to prevent confusion among consumers, who may believe they're buying a product from a certain brand, when in reality it's just a knockoff. And that's why we see so many knockoff Apple products sold in China, but rarely in America, because our trade dress laws protect companies from imitators. In fact, the very first iMac was imitated by an American company called eMachines with a product called the E1. It was clearly a knockoff of the wildly popular iMac, but it didn't do too well since Apple successfully sued the company through a trade dress claim. Now, clearly Apple felt Samsung was doing the same thing by ripping off the iPhone and iPad's trade dress for their various devices, and as you can see from this picture, there are quite a few striking similarities that aren't likely due to sheer coincidence. Next is trademark infringement. And this is where things get a little obvious, because while Samsung may have been able to argue that the similarity in hardware design was incidental, the similarities in software elements like the icons became much more difficult to defend. There are literally hundreds of ways to design any given icon, and in many cases, Samsung just so happened to choose the same visuals as Apple. And third was infringement of design patents. These included the home screen icon layout, the form factor of the iPhone's chassis, and the screen and button designs. So if we add all of that up, we have claims ranging from branding to software design to hardware design. Essentially, every major component of these select Samsung devices Apple claimed were copied from their iPhone. And what did the court think of all this? Well, they ruled in Apple's favor. They ordered Samsung to compensate Apple $1 billion for their infringements and to never do it again in the future. But this wasn't the end of the story. In fact, the two companies were just getting warmed up. Samsung ended up appealing the verdict and countersued, claiming some of Apple's products were infringing on their patents. This legal back and forth continued for years, with both sides enjoying some wins and suffering some losses. Apple managed to ban Samsung's Galaxy Tab from Germany, which forced the company to redesign the device, but Apple was also found guilty of infringing on Samsung's cellular data patent with the AT&T iPhone 4, 3GS, and 3G, as well as models of the original iPad and iPad with 3G data radios, which meant Apple would be banned from selling AT&T models of some iPhones and iPads in the US. But the White House had a chance to veto the decision, which is exactly what President Obama did. Now, the 7-year-long lawsuit war came to an end in June 2008 when Apple and Samsung agreed on an undisclosed settlement. Although it's unknown what that settlement was, it's worth considering how much damage the entire ordeal had on both companies and how little each were compensated in return. But clearly Apple saw the legal battle as a victory when they released this statement. We believe deeply in the value of design, and our teams work tirelessly to create innovative products that delight our customers. This case has always been about more than money. Apple ignited the smartphone revolution with the iPhone, and it is a fact that Apple blatantly copied our design. It is important that we continue to protect the hard work and innovation of so many people at Apple. We're grateful for the jury for their service, and pleased they agree that Samsung should pay for copying our products. Samsung declined to comment. Now, you'd probably imagine that after all those lawsuits, Apple and Samsung would want nothing to do with each other. But it turned out to be quite the opposite. Because Samsung still provides Apple with crucial components for their most popular products, the iPhone X's beautiful OLED display was brought to you by Samsung, as well as its memory chip. And the revenue generated by these component sales are staggering. Samsung earned $110 for each iPhone 10 sold, and since Apple sold an estimated 130 million units, that adds up to over $14 billion for Samsung. Compare that to the component revenue of their own Galaxy S8 at $10 billion, and you begin to understand how symbiotic the relationship is between the two companies. Apple relies on Samsung to provide high-quality components that can be mass-produced at scale, while Samsung relies on Apple to buy the components they make. So the destruction of either company would be detrimental to the other. And I think that's why Tim Cook dialed back on the aggressive stance Steve Jobs took on the Android and Samsung case back in 2010. Jobs said, "I will spend my last dying breath if I need to, and I will spend every penny of Apple's $40 billion in the bank to right this wrong. I'm going to destroy Android because it's a stolen product. I'm willing to go thermonuclear war on this." And although he was referring to Android in that specific quote, those feelings extended to other companies like Samsung, who he thought were also copying Apple's products. But in 2012, Tim Cook made it clear that he preferred a different approach. He said, "I'd highly prefer to settle versus battle. But you know the key thing that's very important is that Apple doesn't become the developer to the world. I've always hated litigation. We need people to invent their own stuff." So although Cook wasn't interested in dragging out Apple's legal disputes against Samsung, he was interested in relying on Samsung less for components, because in 2018, Apple reportedly added LG as a supplier of OLED displays, who began test runs of mass-produced panels near the end of 2018, and many believe Apple will begin using LG panels in the new iPhones released later this year. This will not only improve supply chain reliability, but also give Apple negotiating power with both suppliers, hopefully resulting in less expensive panels. But that isn't to say Apple and Samsung are growing apart, because just a couple months ago, the companies announced a deal that took many tech fans by surprise, and it was that Apple would bring iTunes and movies and TV shows to Samsung smart TVs in addition to AirPlay 2 support, which means not only will users be able to access their existing iTunes library and buy or rent movies and TV shows from the iTunes store, but they'll also be able to play videos, photos, music, podcasts, and more from Apple devices directly to Samsung smart TVs, something that was previously only possible with the Apple TV set-top box. And this is another great example of Apple and Samsung working together in a way that benefits both companies. Samsung will likely sell more TVs since they'll have iTunes and AirPlay, and Apple will likely sell more movies and TV shows since there'll be more people shopping on the iTunes store. So we've recognized that Apple's relationship with Samsung has had its ups and downs, and it's true that they're direct competitors in a number of markets, but moving forward, I think we'll see more cooperation between these two companies rather than conflict, mainly because they've both been challenged by a new rival, Huawei. They're a Chinese-based consumer electronics company that has been exploding in popularity thanks to their inexpensive, high-quality smartphones. Apple and Samsung both made a concerted effort to expand their presence in China to take advantage of their larger consumer market and growing economy, but things didn't go as planned for either company, since Chinese manufacturers like Huawei disrupted the market by undercutting the iPhone and Galaxy while still offering full-featured premium phones. In fact, in the last quarter of 2018, Apple's worldwide smartphone market share dropped 2 percentage points, and Samsung's dropped 1 percentage point, all while Huawei managed to grow their hold on the smartphone market by 4 percentage points, which means they're one of the only companies not experiencing slowing smartphone sales. So it seems as if Apple and Samsung have more or less become natural allies in the last couple of years. They ended the lawsuit war, they're striking deals to help each other access more paying customers, and they still cooperate on component manufacturing. But only time will tell if this trend toward friendliness will continue, or if a new disagreement will cause a divide between the two companies yet again. Now, if you want early access to my next video, be sure to join our Patreon community, and don't forget famous inventions stolen from other people. 10. The telephone. Alexander Graham Bell is largely credited for inventing the telephone after he secured the patent in 1876. But in 2002, the US Congress declared that the real inventor was actually the poor Italian inventor Antonio Meucci. 16 years before Bell's patent, Meucci had successfully demonstrated his teletrafono for the Italian-American press in New York. Meucci sent his invention to the Western Union Telegraph Company in 1872 in an attempt to bring his telephone to market, But when no action was taken and he asked for his prototype back 2 years later, Western Union claimed to have lost it. Bell, who had shared a laboratory with Meucci, filed a patent for a telephone and made a lucrative deal with Western Union. Meucci sued Bell for fraud and appeared to be winning the case, but then he died, bringing an end to court proceedings. 9. Radio. Guglielmo Marconi won the Nobel Prize for his pioneering work on long-distance radio transmissions. However, he did so by infringing on numerous patents held by inventor Nikola Tesla. In England, Marconi used Tesla's technology to demonstrate long-distance radio transmissions. Over the following 3 years, for radio patents in America, but was repeatedly rejected as they were too similar to more than 17 that were already held by Tesla. However, as Marconi continued to improve his demonstrations, he received financial backing from powerful investors in the United States, and in 1904, the US Patent Office reversed their previous decision and gave Marconi a patent for the invention of radio. It was not until 1943, a few months after Tesla's death, that the Supreme Court ruled to uphold Tesla's radio patent. 8. Lasers. Gordon Gould is widely credited for the invention of the laser, but it took a 30-year patent war for him to secure this title. As a graduate student at Columbia University, Gould discussed his idea of how to build a laser with physics professor Charles H. Towns. Coining the term laser, Gould wrote down his idea in a notebook, which he legally protected. Meanwhile, 2 years later in 1959, Towns successfully patented the laser, leading to Gould suing. Gould was locked in legal battles for 30 years, securing and defending laser patents. But in 1988, he finally won his last court battle and was able to receive royalties from anyone making lasers, a settlement worth millions. 7. Anyway Up Cup. Amateur inventor Mandy Haberman came up with a new type of cup with a slit valve that prevented spills after seeing a toddler pour juice over a carpet. Haberman patented the valve and showed her cup to big brands in an attempt to sell her product to them. After seeing her invention, children's company Jackal International stole the invention and bought out her cup under the global Tommy Tippy brand. Haberman was forced to take the manufacturing giant Jackal International to court and sue for patent infringement. She eventually won the case, including damages, and is now selling 10 million Anyway Up cups a year. 6. The telescope. Galileo's most famous invention, even though he didn't actually invent it. The first person to apply for a patent for the telescope was Dutch eyeglass maker Hans Lippershey in 1608, but the patent was never granted as the invention was deemed too easy to reproduce. A year later, news of the Dutch perspective glasses had spread to Italy, leading to Galileo engineering his own copy. He improved the magnification of Lippershey's version and was the first to methodically plot the movement of Venus. And he disproved the dominant theory at the time that the Earth was at the center of the universe. 5. Quick release socket wrench. Peter Roberts was 18 years old and working at department store Sears when he invented and patented the quick release socket wrench. Sears bought the patent from Roberts for just $10,000, telling him that his invention wouldn't sell well. It wasn't until Roberts saw his wrench in a Sears catalog he learned that his invention was an enormous success and that Sears had sold 26 million of his wrenches for a profit of $44 million within just a year. Roberts spent 25 years locked in legal battles with Sears, suing them for cheating him out of his rightful royalties. He eventually settled for $8.2 million. 4. Monopoly. Charles Darrow became the first game designer to become a millionaire when he sold the board game Monopoly to toy company the Parker Brothers in 1935. But in reality, the famous board game was patented in 1904 by Lizzie Magie under the title The Landlord's Game. Versions of her game were played for 30 years before Darrow took his own version to the Parker Brothers. The Parker Brothers paid Magie just $500 to buy the patent to The Landlord's Game, while Darrow went on to be hailed as an American innovator. 3. Intermittent windshield wipers. Robert Kearns lost his job, marriage, and even his mental health when his invention was stolen by the big 3 automakers. His mechanism allowed windshield wipers to pause in between swipes. Kearns showed his invention to Ford, General Motors, and Chrysler in an unsuccessful attempt to license his new technology with them. But despite having more than 30 patents for his invention, all 3 car manufacturers began to install his mechanism into their cars without his knowledge. Kearns spent 20 years battling car makers in court for patent infringement, eventually winning tens of millions of dollars from Ford and Chrysler. However, he was unable to reclaim his invention, which by this point had been adopted by car manufacturers the world over. 2. Brown paper bag machine. Margaret Knight was one of the most famous female inventors of the 19th century and one of the first to secure a patent. While working in a paper bag plant, Knight had the revolutionary idea that paper bags would pack more if they had a flat bottom. So she set about creating a machine to automatically produce them. Initially, she created a working wooden model of her invention, but while developing her metal prototype, machinist Charles Annan stole Knight's design and patented the device himself. Knight sued and was ultimately able to prove that she was the real inventor. Her machine had a huge impact on the paper industry, and the principles behind it are still used to this day. 1. Light bulb. Thomas Edison was a prolific inventor and particularly famous for inventing a light bulb suitable for indoor use. To do this, Edison attempted to improve on British inventor Joseph Swan's version of the light bulb. He secured an American patent for his improvements, and to sell the bulbs, he began a marketing campaign which stated that he was the real inventor. However, in England, Swan had already improved the light bulb a year earlier. To avoid a possible court battle with Swan, Edison reached out and formed a joint light bulb manufacturing company to release the invention in Britain. Swan allowed Edison to sell the bulbs in America and retain his reputation as the inventor of the light bulb that we still use today.
Music on this video is by our friend and all-time.
So we just saw a video that made us understand the importance of patenting one's inventions, and also the importance of securing and protecting one's intellectual properties. And this is also another video that explains why one should protect the intellectual property.
Pursue the kiosks. You'll see some pretty bad knockoffs. Maybe you've seen a friend or coworker sporting a bag they're sure is real, but you can tell it's fake from across the room. It's easy to be fooled by knockoffs, but the people behind these funniest knockoff fails weren't even trying.
Amazing!
Number 20. I grew up watching cartoons, and I'd recognize Mickey Mouse anywhere. These imitations, not so much. The lovely rat? What a coincidence. That rat has big mouse ears. Not to mention he isn't lovely at all. But hey, if you're not into the lovely version of Mickey, that's okay. Maybe you're more attracted to the bad boys, like dangerous Mickey Mouse here. Number 19. This brings us to another franchise I fondly remember from childhood, the Teenage Mutant Ninja Turtles. Who didn't love the cool kung fu moves and those hard plastic shells? But whoever designed these ripoffs should be hiding under a shell of their own, especially since the Turtles were all about fighting crime, and selling knockoffs is definitely one of those. Number 18. Speaking of fighting crime, if the Teenage Mutant Ninja Turtles need backup, they could just call in the Sense of Right Alliance. What, you never heard of them? Neither did I, but they look suspiciously like some other famous comic book characters I can't quite place. And if our Sense of Right Alliance pals need help, they could just call in a favor from Robert Kopp. You know, that half-robot, half-cop guy with the exceedingly catchy moniker of Robert Kopp. Just rolls off the tongue, doesn't it? Number 17. I'd expect to see knockoffs in toys and expensive designer duds, but I don't anticipate seeing them in the soda aisle, considering brand name soda isn't that posh. However, it turns out that even beverage makers like to knock off name brands, like this Mountain Lightning. Well, at least they didn't call it Mountain Dew, although that's probably what it tastes like. Number 16. These markers look like familiar Sharpies from a distance, and possibly even up close. But take a better look at the name. What are Scurpies? No offense, but that sounds like something you might catch if you forgot all those health class lectures about safe sex. Markers? No thanks. I'll stick with the regular Sharpie. Number 15. Some people call their favorite coffee house by a different name, like 10 Bucks Coffee. But Sunbucks is a new one. You've got to love the mane on that dog logo. He's one hairy mutt. As for this pan burger partner, well, there's a pan, and there appear to be some burger bits. It does vaguely resemble its hamburger helper cousin, but Panburger Partner just doesn't have that catchy ring or the talking hand. Number 14. Some of these knockoffs are so bad they could drive you to drink. Just not this knockoff alcohol. If someone gives you a bottle of whiskey at the next holiday, be sure to take a close look at the label and make sure it's not John's Daphne or this Johnny Worker's Red Labial. Actually, this whole label might belong in the adult reading material section of the store. Number 13. Who doesn't love to play video games? Someone who bought one of these cheap knockoffs, I'm guessing. Anyone up for a game on the old Polystation 3? Good luck finding cartridges to fit that. Or this X Game 360. There's another Polystation, first generation this time. Oh hey, this cartridge will probably work. It's Super Wonderful Mario. Way better than regular Super Mario because, you know, he's super and wonderful. Number 12. By now, everyone and their dog, not to mention cat, has played Angry Birds. Yes, the inventors of these knockoff pencil toppers wanted to make use of their thesaurus. These birds aren't angry. They're just expressing their feelings in a non-productive way, right? Of course, it could have been worse. At least they didn't get labeled the hangry birds. Number 11. Footwear is another category of products commonly struck by rip-off artists. In this case, someone tried to sneak these fake sneakers past consumers as real. Air Jordan 13 Gucci? Anyone? I have a bad feeling if you actually tried to play basketball in Jordans, they'd probably fall apart. But if you're not the athletic type, check out this other fake shoe, the Air Jordan 11. It's got a special picture of Barack Obama, who clearly is so desperate for cash he's endorsing sneakers now. I guess making speeches doesn't pay that well after all. The economy. What are you gonna do? Number 10. Everyone's heard of the Fooey, the fake Louis Vuitton bag. Some of these are more convincing than others, but the person responsible for this one just wasn't even trying. Actual Louis bags are never put together with cheap glue and cheaper stitching. And let's be honest, if Louis wanted to make a genuine LV car, would they pick an old sedan? Then there's the person who decided to rip off Hugo Boss and didn't even bother to spell the designer's name right or correctly translate it into another language. Hugo Boss is a popular brand of clothes and cologne, but I'm not sure what Juan Pizzas is. Number 9. Picking out a wedding or prom dress can be time-consuming, not to mention expensive. I don't blame anyone who wants to just skip the hassle and buy a dress online. Unfortunately, many shoppers who do this get something very, very different than the dress pictured, like this side-by-side comparison. On the left, you have a perfectly tailored dress. On the right, something like a sack of potatoes wearing a fluffy skirt. Up next is this dress, which isn't even the same color as the one advertised. Although, I certainly give the designer points for providing that something blue superstitious brides want to wear on their wedding day. I'm not even sure what went wrong with this last one, but this prom dress appears to have one changed color, gotten shorter, and lost a lot of tailoring around the waist. But hey, it might work if you're going to prom at Candyland High. Number 8. Back on the electronics aisle, former President Barack Obama must be really desperate for cash with all these tacky product endorsements. I mean, I know he supposedly loved his BlackBerry, but I never heard him express a fondness for the knockoff BlackBerry. Of course, back when he was in office, presidents didn't tweet all day, so maybe I just missed the sent from BlackBerry signature, or not. Number 7. The iPno 06 just rolls off the tongue, doesn't it? Lacking any presidential endorsements. This one must sell itself with its high quality and catchy title. Or maybe they're just hoping you won't look too closely at the box. Whatever. Number 6. Who doesn't remember those old Trix commercials from childhood? Silly rabbit, Trix are for kids. Don't feel badly for that rabbit though. I'm sure he just goes to the store and buys a box of these pranks. Hopefully what they lack in the authentic taste, they make up for in extra sugar, so he can keep hopping frantically around. Maybe next time he'll get to the real stuff for the kids. Number 5. This is like one of those what's wrong with this picture games. Here we have the Android iPad, the box bearing the little robot logo I associate with Android. And yet it's somehow an iPad. Perhaps it's from an alternate universe where the two companies combined. This theory might also explain the iPad. Now, you don't need an eye doctor. It says iPad. While you're using those fabulous tablets, you might want to listen to some music. Need some Sonya headphones to go with that? Number 4. Darth Vader is really branching out and trying new things in the latest Star Wars movie. He's given up demolishing Death Stars to be a motorcycle cop. Sounds bizarre to us too. But why judge? Surely conquering entire planets and plotting galaxy domination can't be that easy. Sometimes you need to pick manageable goals, right, Darth? Number 3. Now this movie character at least looks something like himself. Too bad he's in the wrong movie. Toy Special 3. Poor Buzz is frozen with shock. He always thought he was in Toy Story. Number 2. There are so many things wrong here. I don't even know where to start. For one, I'm pretty sure the Power Rangers never went to space. Why bother when you can fly around Earth all you want? But then there's the fact that these guys in the middle aren't Power Rangers or heroes from a show about space. That's Batman and Spider-Man. And apparently they're even more hard for cash than a former president, because they're doing a cameo in this Power Rangers of Space movie. Number 1. Everyone remembers the iconic blue iMac of the early 2000s. If you didn't have one yourself, you probably knew someone who did. Unfortunately, this knockoff was made by eMachines in 2012. Apple ended up taking eMachines to court because apparently the similarities had them feeling as blue as the famous original computer. Have you seen a shining example of a really hideous knockoff? Let me know in the comment section down